The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
The court calls the case of State of West Virginia versus Natalie Cochran. We continue in the trial. The case number is 23-F-343K. All parties are present, including the defendant, although we are missing Ms. Acord. Is she going to join us?
She will be joining us. She is at the office, but she's working on some stuff and she'll be here.
All right, thank you.
But I have her permission to go over the court's instructions on behalf of the prosecutor's office.
All right, thank you. I do have the individual submissions from the state and from the defense. I've prepared a continuous charge to the jury that incorporates all of the submissions, both from the state and the defense, and sets it forth in the court's traditional charge. I suggest that maybe we could go through that page by page. Again, I've mixed up your offerings a little bit, but all of them should be included in the mix. So you have a copy there of the proposed court charge.
Yes, sir.
All right, let's go through it page by page and raise any concerns that you have. Is there any problem with page 1?
Nothing to say, Your Honor. Thank you.
No, Your Honor.
All right, page 2,
Nothing from the state. Thank you.
No, Your Honor.
page 3,
Nothing from the state.
No, Your Honor.
page 4,
Also nothing from the state.
Nothing, Your Honor.
page 5,
Nothing from the state.
No, Your Honor.
page 6,
Nothing from the state.
page 7, and you'll note that I put in the squib about expert testimony.
Yeah, and in the paragraph after that, Your Honor, there's some gender change that needs to be made, I believe.
Okay.
Well,
Your Honor,
Yes.
I believe Mr. Victor has a comment or objection.
all right, let me handle this. There is no paragraph on the defendant's testimony or lack thereof, Your Honor. It has to be.
Well, I do. I think
It's
I have
in
that,
there.
but it's towards the last. I can move it.
Okay.
I'll find it.
Well, I'm probably looking.
I believe I did see that, Your Honor, but I can't locate it right offhand.
Well, everything gets lost. You know where it is, Colleen? Oh, it's page 12, and it's the second paragraph that starts with, as a defendant is presumed innocent of the charges brought against her.
And we'll get to that.
Okay.
Okay.
All right, let's go back to page 7 and see if there are any issues or objections to any of the material on page 7.
Your Honor, the last paragraph may I remain seated so I
Certainly, yes.
I believe that the offense charged in the indictment is murder in the first degree. The jury may return, I believe, 3 verdicts here rather than 2, because they can return the verdict of murder in the first degree, guilty of involuntary manslaughter, or not guilty.
Okay, we need to think about how to word this because the jury will be confused. We've never raised the issue of involuntary manslaughter with them, and to just pop this on them may cause some confusion. Any suggestions, Mr. Truman?
The state does concur that the language of the first paragraph of number 7 should likely be changed. And it may be just as...
Could we put one of the offenses charged in the indictment as murder of the first degree?
Yeah, that would work.
How's that, Mr. Victor?
But what is charged in the indictment is really murder.
Well, that's true.
Your Honor, may I suggest?
Yeah.
As number 3, or the lesser included offense of involuntary manslaughter.
See, the way that we have it is actually correct because it says the offense charged in the indictment in this case is murder of the first degree. That's right. You may return one of 2 verdicts under the indictment.
Okay, all right, I stand corrected.
So we're okay with it.
Right, but there has to be nevertheless recognition of...
Yeah, and it's right after that on page 8. No, I'm sorry, not 8. Page 10.
And Your Honor, I'm sure Mr. Victor will volunteer some information. At the bottom of page 10, you say, you're talking about a distinguishing feature between voluntary and involuntary manslaughter. Voluntary manslaughter is not a consideration.
Right. I think we need to remove that. That somebody submitted that, and I guess it was either you or Mr. Victor.
No, I don't think we're there yet, Judge. I'm looking at page 8, and page 8 starts with murder of the first degree. And by the way, I don't know, this is a very, very minor thing, but I think we should be consistent with capitalizing certain things.
Okay. I think that's a big deal.
That's just,
Okay.
suggestion. But before, murder in the first degree is any felonious, willful, malicious, deliberate, unlawful. It has to be unpremeditated. The premeditation is the most important factor of the murder in the first degree. So it has to be there.
Okay.
And I don't know if we need to put the West Virginia Code section there for the jury.
All right, I'll remove that.
And then, of course, in that instruction, in the paragraph starting with before the defendant can be convicted of murder in the first degree, paragraph 4, feloniously, willfully, maliciously, deliberately, unlawfully, and premeditatedly.
Okay.
And then, I believe, Your Honor, that at the end of page 8, we probably need to go and describe what is now on page 10, and that is murder of the first degree consists of an intentional, deliberate, and premeditated killing. And that definition is the definition of premeditation. Because otherwise we're going straight to malice, and we're discussing malice, and then we're going back to murder in the first degree.
Okay, so we just need to move that before we discuss malice.
I would so ask. Then And I think that in that paragraph on page 10, describing premeditation, in the third line, well, it starts with the duration of that period. I would say that this is the, this should read the duration of premeditation, or of the period of premeditation cannot be arbitrarily fixed, and that's under Guthrie.
Okay. Any problems, Mr. Truman?
No.
Now, this is what I have. The duration of that period of premeditation cannot be arbitrarily fixed.
Yes, Your Honor.
Then I'm going to move this entire paragraph to the top of page 9 before malice.
Yes, Your Honor. Now, and then, since we're describing the offenses which the jury can consider, I would also move involuntary manslaughter definition prior to the definition of malice, because we've already talked about the definition of the first-degree murder. So now I think the next logical thing is to discuss the involuntary manslaughter, and then discuss the definitions of malice, and just about it.
Okay, where do you want to move that to now, Mr. Victor?
Before the top of page 9, before malice.
Okay.
Involuntary manslaughter is committed when a person caused the unintentional death of another person. Now, in that paragraph, I think we have to modify this paragraph because, as Mr. Selden astutely noticed, this paragraph deals also with voluntary manslaughter, and we don't have any voluntary manslaughter anywhere. So I would propose the court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is either the main characteristic or the main feature of involuntary manslaughter.
Okay, if you can write that down, you talk a lot faster than I can.
Oh, I'm
write.
sorry, Your Honor.
That's okay.
I'm sorry.
I mean, I'll work it out the way you want it, but you'll need to write it down.
I think that the, okay, I have it.
Matthew.
The main component were, okay.
Involuntary manslaughter. Take out distinguishing feature between.
Okay, main components. And then, Your Honor, we're arriving at the definition of malice. I've been doing some research on malice, and in the first paragraph on malice that is right now on page 9, the last full sentence, malice and intent can also be inferred from the defendant's intentional use of a deadly weapon under circumstances which doesn't give rise to legal excuse. I believe this may have been this may be one of those instructions that shifts the burden of proof to the defendant. Although I believe that there is the State versus Jenkins case, and it's probably all right, but I
think this is a pattern instruction.
Yeah.
I've seen it many times. I don't know where Mr. Truman dug it up, but maybe right out of a form book.
I think
It's just one of those stock instructions that the state keeps, and it's been offered as long as I can remember.
and that's
If
why
it needs to be changed, then let's hear what
We
the
can
basis of
we can change it.
I think inference is all right, but then in the next sentence, implied, And once the jury starts,
Okay,
Making
in
something
the next
as an
sentence where it
implication.
says it may be inferred or implied, what if we get rid of or implied?
yes. Uh,
That's in there twice, so in the next sentence,
Okay.
get rid of it.
Right.
I see it up in the first paragraph too. Can we change implied to inferred?
Yes, Your Honor.
Okay,
Now, when we talk about involuntary manslaughter, I think that a full definition of involuntary manslaughter should be probably given, and that is, I will read it, and maybe I'll read it quickly, and then we'll try to parse it. A person is guilty of involuntary manslaughter when a result of the doing of an unlawful act in a reckless or grossly negligent manner, or the doing of a lawful act in a reckless or grossly negligent manner, he causes the death of another person.
okay.
Was that in an instruction the defense
That wasn't
submitted?
an
No,
instruction.
that's
Oh, you're adding this.
right. I think that would be the appropriate definition of involuntary manslaughter.
Well, do we have that in writing? Can you submit
I
that?
can write it in here and present it to you.
Okay. Does that sound all right with you, Mr. Truman?
Yeah, I'd like to see what it,
Okay.
Okay,
What it
let's
says
write-
before I comment on
Normally,
it.
there are written submissions that the court considers. Okay, we're okay with the elements of involuntary manslaughter.
Yes, Your Honor. I'll write it down and submit it
Okay.
to Mr. Truman. Now, let's see.
Are we down to page 12?
can we go back to page 10? And the only
Sure.
reason the state is always paranoid about submitting the Wyatt instruction about knowingly,
Yeah.
which is one of the dumber opinions to ever come out of Charleston. But aside from editorializing, I don't know if we need that paragraph. It's really not an element of first-degree murder.
That's fine.
I mean, it doesn't necessarily hurt anything, but
You're talking about paragraph 2 on
yeah,
page
a
10.
person acts knowingly.
You want to remove it in its
Well,
entirety.
I'm just raising the issue because it's not an element. I think it's been offered in every case since Wyatt was decided. But it's there. I thought I'd raise the issue.
That's fine.
Can we just omit it?
We can remove it, sure.
Okay.
Now, on page 12, the first paragraph, that instruction is always questionable to me because this one, I believe, shifts the burden of proof to the defense. That you may
Okay,
infer-
I don't know that we need it. If we take this out, Mr. Truman, will it be a strong objection?
A vociferous, okay, go ahead and take it out.
Okay, I'm going to remove it.
Although we do not accept the argument that it shifts the burden, I don't think it does.
Well, I've put it in virtually every
I know.
every charge that I've given, but I don't know that we absolutely
That's
need
fine.
it. Okay.
Once since I stand corrected about the defendant testifying or not testifying instruction, which is on page 12, I always insisted on the word must, and that is 1, 2, 3, 4, 5, 6. Seventh line in the first, in the paragraph that starts with, as the defendant is presumed innocent. It says that you should disregard it, no, not is, it,
Yeah,
and not discuss it.
okay.
I think it should read you must entirely disregard
Okay.
it, because it's,
Any problems, Mr. Truman?
None.
You must entirely disregard it and not discuss it.
that's right.
How's that?
That's fine, Your Honor.
Anything else on page 12?
I think there might be in the next paragraph, second line. I think that wither is supposed to be weather.
Well, it was whether it just. Okay, I'll change wither to weather. How's that?
That sounds like a plane.
And I don't have any other objections to the end of the document.
Okay. Page 13.
No, Your Honor.
Any problems, Mr. Truman?
This is getting kind of repetitive. But other than margin issues. with
Well, we
page
can't do
13.
anything about that because that results from the way it was submitted.
Oh.
We tried,
Oh, okay.
but it's just, we're just gonna have to live with it.
Okay.
Anything on 14?
Second full paragraph is a gender issue, second line.
Are we on 14?
Yes.
Second paragraph?
Second full paragraph. You have to believe that the defendant.
Oh, I see it, okay. Change him to her.
Right. And then the last line, committed the crime. I don't think it's an of that you need there. That just needs to be deleted.
Run that by me again.
Yes, sir. The last line on page 14.
Yeah.
To establish the defendant committed the crime, I don't think of needs to be in there.
Right.
Oh. Got it. Okay. Page 15.
Nothing from the defendant.
Nothing from the state, Your Honor.
Okay. Page 16.
I think the bottom, the last paragraph in that, the law presumes, that's all covered on page 2 of the charge.
I agree, Your Honor, and
Okay.
I think that if we need to have it, it can be moved to the beginning of the instructions, but I don't.
Yeah, which it's on page 2.
Okay, I propose to take out the entire paragraph at the bottom of page 16, and it runs through the top of page 17. Is that okay?
Yes.
That's fine, Your Honor, yeah.
And likewise, on page 17, since we're there, the last paragraph is also covered on page 1 of the charge. About the indictment.
I agree.
Now, where is it?
The last paragraph on page 17 is also
okay.
the
I'm
first.
going to remove
Yeah.
the last paragraph on page 17, which runs one line on the top of page 18. Okay, now page 18.
I don't know that this is an objection, but I don't think the courts admonished the jury as to any statements that were limited for the purpose of impeachment. I don't recall it if it happened that way.
Well, it didn't. This is just stock language, which I can remove if you want it.
Well, I mean, I just don't think that this
It
happened.
doesn't pertain to our case.
No, it really
I
doesn't.
propose to take out the second long and full paragraph on page 18. Is that okay with you, Mr. Victor?
Yes, sir. That's fine.
I don't know that we've ever done that, but it's always in the charge. A lot of this came from Judge Ashworth.
Yes, it did.
Okay, page 19. I hear a sigh.
Aren't we slightly repeating ourselves with this?
We are.
We are.
All possible doubt.
Mr. Truman has always complained
I
about
do a lot
that.
of whining about that. Yes, that's true.
It inures to your client's benefit, but I'll take it out. What is it that you want removed?
The last paragraph, starting with the state is not required to prove guilt beyond all possible doubt.
Okay,
We've heard it before.
okay. Is that all right, Mr. Truman?
Oh, yes. Thank you.
I want to repeat it as many times as possible. But I'll defer to Mr. Victor.
Okay, now page 20.
The only thing in this is when it's a murder case, you must not discuss or consider punishment. And the court has, a few pages before that, has discussed punishment in terms of what happens if the jury finds the defendant guilty of the indictment. I don't really know how to reconcile those two things. It's a proper statement of the law.
Well, I can
But-
just remove that squib altogether. I don't know that we have to have it.
Well, judging by the prior instructions and because it's murder in the first degree, I think that the jury will, by virtue of the nature of the charge, have to discuss the punishment.
I propose to just take out the line, you must not discuss or consider punishment or permit any speculation concerning punishment to influence your verdict in this case.
Of course, there is this involuntary manslaughter, which, by the way, I don't think that the jury should ever be advised whether it's a felony or a misdemeanor, but,
I don't think we should tell them that.
right. And,
I'm going to remove this line.
but that line is superfluous in murder case.
Okay, anything else on page 20?
Nothing from the state, Your Honor.
No, Your Honor.
21.
No?
No,
Nothing
Your
from the
Honor.
state.
Will the court advise the jury on the selection of the foreperson?
Oh,
or
yes.
it's done later?
Sure. Now, I'm going to have my trusty law clerk Colleen redo this, and I need some help, especially from you, Mr. Victor, because some of the instructions you read into the record from a book or from rote, and she will ask me what I want in there, and I wasn't able to write down everything that was pertinent.
I'm at the court's disposal.
Okay. All right, I'm going to revamp this, and we'll get ready for the jury. Hopefully, they'll arrive at 10 o'clock as instructed, and we can go forward.
Okay.
In terms of the schedule, and again, I don't want anybody to necessarily tip their hand, but I anticipate that the state or that the defense will rest. Is that right, Mr. Victor?
It is correct, Your Honor, yes.
And then the state may have one rebuttal witness.
Yes, sir.
Okay. All right. let's get to work, and I'll need at least Mr. Victor, if not all of you, to help us straighten out some of the elements and some of the charges for the jury to consider. We'll take a brief recess. morning, everyone.
Morning, Your Honor.
And we are continuing in the trial of State versus Cochran. We have been working busily on instructions, and I have a draft that I have handed out. Hopefully, Mr. Truman, you've got a copy there. Okay,
Yes, sir.
I'm not rushing you. We'll have some time to discuss it. I just want to make sure you got your copy.
I did. Yes, sir.
All right. Any matters to take up at this time before we bring out the jury and continue?
The state
Your
will need
Honor.
the equipment for the next witness.
Okay. We'll fire that up.
I will carry it.
You go with.
Yeah, and I will carry it.
All right. All right, now, Mr. Truman, if you'd take some time to select the documents that you wish to present.
Handing them to defense counsel as we speak. I'll take these back. Oh, yeah.
Sure.
Make your argument. I'm not giving you. Make your argument. Because apparently we cannot agree on the Sharia, the import information. So we have to look at the law. Yes, I agree. Because I think we will be wasting Jewish. I absolutely agree with you. So we didn't cause. We didn't stop. Your children. Children. May we again.
All right. All right, are we ready for the jury now? State
No,
prepared?
Your Honor, we are only halfway through these documents. A lot of them appear to be unsubstantiated, irrelevant, but we still have to go through about half the documents.
Well, we've got to go forward, and so I don't want to leave the jury in there much longer. Perhaps you can review them and do it on the fly.
Well, Your Honor, unfortunately, we would have to go through each and every document as they're being testified to. We need to view them.
Let me ask you this. Have you been provided with these documents?
We honestly don't know, Your Honor. We were provided with 100,000 files. I can't tell if we did or not, and we have not reviewed these prior to the presentation.
Let me ask Mr. Truman, did the state provide the defense with these documents?
We did. This is the download of the defendant's phone. We separated them, and we've already agreed not to submit all of the downloads of the phone messages that are not already in evidence. So it's down to this stack of a few right there. The state does have a suggestion. In order to expedite this, we can probably eliminate some of these, and that could save us some time.
Okay.
What number are you on?
11.
Good. We'll eliminate 11. I said we'll eliminate 11. 12. No, this isn't on record.
They're engaging in another powwow.
Yes. 15. 17.
No, keep going, keep going.
18. So 11, 12, 15, 17, and 18. We'll withdraw.
Okay. So now, do you want to review those? Do you want to withdraw any of these?
No, I told you the ones I was willing to withdraw.
Do you want to have another 5 minutes? Because we're close to the
Your Honor, respectfully, could we have an additional 5 minutes to, the state has eliminated a few, but.
All right. I'm going to hold you to that, Mr. Selden. I'm going to time 5 minutes.
Okay. How much hurriedly go through?
All right, are we ready for the jury now?
Your Honor, we only have one exhibit to review. If we could have 1 minute.
All right, 1 minute. All right, bring in the jury bailiff. I'll ask the defense to call their next witness, and presumably you'll rest.
Your Honor, while we're waiting for the jury to come in, we would like, especially, we would like copies of these to go through as they're being testified to.
Okay. Good morning, ladies and gentlemen of the jury. Good morning. I'm glad to see that you're still smiling. I apologize for the extreme delays. We have not been sitting around talking about West Virginia basketball or Marshall football or even politics. The attorneys and I have been working diligently since 8:30 this morning to try to streamline this trial and get it in a posture for your consideration. I appreciate your patience so much. We are now in a position to go forward. If you will recall, we are still on the defense case in chief, so I will ask Mr. Selden to please call the defendant's next witness.
Your Honor, we have no other witnesses. We are resting the defense case.
All right, thank you. Let me inquire of the state if there will be a case in rebuttal.
Your Honor, the state does have one witness to call in rebuttal.
All right, please call your witness.
State recalls Robert Heinzman.
Mr. Heinzman, I remind you, you are still under oath. You may have a seat. You may proceed, Mr. Truman.
Thank you, Your Honor. Mr. Heinzman, hand you what's been, at this point, it's part of State's Exhibit 3. Ask you to review that as well as the second page, which is also an abstract from...
You might request that we get copies so we can look at them while they're being testified to. If we could simply copy them very quickly.
Does the state have copies available?
We do not. I mean, we can make them, but...
Okay. I'll ask Ms. Brown Bailey or the deputy to make the copies real quick. How many do we need?
He's the only one that wants one, I guess.
One.
Yes, Your Honor,
Okay.
Your Honor, and for the court's information, Mr. Victor will be cross-examining this witness.
Oh, all right. With our luck, the copier may have run out of paper. That's right.
ask some preliminary questions.
Okay, go ahead.
You previously testified that you and Tim Bledsoe, both retired troopers, were the lead investigators in the two cases, correct?
That's correct.
As part of your investigation, did you interview the defendant's children?
No, we did not.
Why not?
At the time of the investigation, and more specifically between March and June, March is when we began the investigation. June is when we executed a search warrant on the defendant's residence. During that period, we were collecting information from third-party records. We were collecting information from witnesses, from financial institutions. And there was nothing in that 3-month period to indicate that there would be a need to speak to the children. The second and most important thing was their age. They were very young at the time. One was 10 or 11 and one was 13. And we were looking at the business of the Cochrans. We were looking at the Cochrans individually. So there was no indication or any reason to speak to the children. And then the final reason we wouldn't speak to the children is we've been long taught in law enforcement and investigations that you don't speak to children under the age of 18. And there's some tolerance there with 16, 17, 18-year-olds, but you don't speak to anyone that young without a parent's permission or without an attorney present. So we would not, by normal operating procedures, have spoken to the children.
You were in the courtroom when the two children testified on behalf of the defendant, correct?
I was.
And in their testimony, they indicated to you who actually ran the company businesses.
I did hear that testimony, yes.
And essentially, what were the children saying as to who was controlling the Cochran's businesses?
The children put a lot of responsibility or
I'm going to
Object to this. The jury heard the evidence. The jury can draw whatever conclusions from the children's testimony. This witness does not need to editorialize on that.
Sustained.
You're being recalled as a witness for the purpose of rebutting the testimony provided by the children. Is that
Yes.
correct? Okay. Thank you. Hand you an abstract from what's been admitted as State's Exhibit 3. Ask you to look at that as well as a second page, also an abstract of what's been admitted as State's Exhibit 3. Recognize those documents?
I do.
What are they?
These are text message communications between the defendant, Ms. Cochran, and Stephanie Hamilton.
Have those back, please. At 10:15, the defendant sends a text to Stephanie Hamilton. Can you put that in some kind of context as what's going on there?
Natalie Cochran is offering Stephanie Hamilton an opportunity to invest in a government contract dealing with medical
The
equipment.
document speaks for itself. Again, we don't need any editorialization as to what these documents are, and what they speak of.
Could the state respond to that?
Sure.
That's not accurate. Those are statements taken, and they don't say anything about a contract. It says there are two today. Two what? I think it's fair to put that in context with the witness's investigation and what he found that meant.
And for that matter, these documents do not indicate any interlocutor of Natalie Cochran. We have no idea who this is.
Well, I think we do need some explanation from the witness, and so I'll allow it. I'll overrule the objection. You may proceed, Mr. Truman.
Thank you.
Ms. Cochran is offering an opportunity to invest in two contracts or to consult on these contracts. They deal with surgical masks and betadine swabs, medical equipment. Ms. Hamilton was in the medical field.
Okay. Here's another text, and this is also a download from the defendant's phone, correct?
Yes,
And
from Ms. Hamilton's phone.
correct. And this is April 26th of 2019.
Yes.
And the defendant responds, that means next Friday is payday.
I'm going to object to this, Your Honor. This is way past Michael Cochran's death. This document is irrelevant.
What is the date on this?
The date,
Yes.
April 26th. And the purpose of this testimony is to show that the defendant continued to run the business as she had before.
I'll allow it. Overruled.
Thank you. Trying to next hand you an abstract from State's Exhibit 2. Could identify that?
Yes.
What is it?
This is a text message between Natalie Cochran and Chris Davis on February the 6th, 2019.
Judge, I think we really need to approach the bench at this point.
All right. Continue, Mr. Truman.
Thank you, Your Honor. February 6, 2019, at 9:27. That's a text from the defendant to whom?
Chris Davis.
We'll have these marked collectively, but if you could take a review of those documents. And if I could have this marked as States 34, please.
All right.
No, this will be State's
Well, we
Exhibit
didn't-
number 37.
We're not, those weren't allowed.
These aren't allowed?
No,
These right here,
right.
number 35.
What's the
30
number?
34 and 35, I think. Or 35 and 30, 35 and 36.
So those are not going to be admitted?
These, well, the ones that you marked previously are not. It's this one in its stead.
Okay, well, it's gonna be 37, because I can't.
That's
see it.
fine, sure.
Okay. This is defendant's exhibit number 37, Your Honor.
States.
Thank
I
you.
mean, states, I'm sorry.
States 37.
Yes, sir.
Okay.
Thank you. Stage 37, marked for identification. Can you tell us what that is?
These are text messages between Natalie Cochran and Wendy Poteet.
Who's Wendy Poteet?
Wendy Poteet would be the sister of Natalie Cochran.
And how did you acquire those documents?
These documents, they're cell phone text message documents. These were recovered from Natalie Cochran's cell phone subsequent to the search warrant executed at her residence. The cell phone is given to a forensic examiner, and they do an electronic download of all the data on the cell phone. And these are pages from that extract.
And that was from a search warrant?
Yes, sir.
Now, we don't necessarily have to go through all of these. Let's just put a few up here to show where this is going.
I'm sorry, which one is this?
4.
4.
Oops, can't get anything out of that. Once again, these are text messages between the defendant and her sister,
Yes.
and she's offering a contract?
Wendy Poteet was already a investor victim of the contracts, and she is,
We object to the characterization investing victim. We don't know anything about Ms. Poteet.
All right, that's a fair objection if you'll refrain from speaking of her as a victim,
yes,
please.
Your Honor.
Continue.
Wendy Poteet was an investor, and this is reference to a contract that she is owed money on. And Ms. Cochran is advising her that she's going to be paid by certified check.
Once again,
This is a text message.
Your Honor, can we please have this identified? Which document?
number 5.
Text message, again, between Natalie Cochran and Wendy Poteet, where Natalie is offering additional contracts for Wendy to invest in on February 18th of 2019.
Now, collectively, is there a pattern emerging here in terms of the defendant's conduct of the business?
I'm going to object to this question. That's argumentative.
Or we could just go through slide by slide.
Overruled. Continue.
Is there?
These contracts were dated after the date that Michael Cochran collapsed on February 6th. So this is a continuation of these illegal business operations, the investment, the Ponzi scheme that we'd spoken about. This is a continuation of those after Michael's not available.
This time for sure. Please.
This will be State's Exhibit number 38, Your Honor.
Very well.
Before I go south of these. This is the one. Let me give that back. Take this. Hand you what's been marked for identification as States 38, please. You recognize that?
I do. I do.
What is it?
Which number is it?
Oh, I'm sorry.
For the,
Yes. Yeah.
beginning,
22, 23, 10,
10, okay,
13, 14,
okay.
16, 19, 20, 21,
Okay,
22,
so now we're
23.
looking at 10.
Collectively at the moment, but
Okay, all right.
they're not all available, but exhibits 10 through 23, or tabs 10 through 23, what is that?
These are all text messages specifically between Natalie Cochran and Michael Cochran, ranging from August of 2018 to February 5th of 2019.
5th or 6th?
These end on the 5th, February 5th of 2019.
This is page 2 of number 11. Who's that to and from?
This text message block is Natalie Cochran's text message that she has sent to Michael Cochran.
Do those numbers mean anything to you?
These are dollar amounts that she has told Michael are owed to them and their business for government contracts that they have sold or obtained, been awarded would be the correct term. She's
Are you done with that one?
You want me to finish, Mr. Truman?
Please, yes.
The date of this text was on August 27th, and with these dollar amounts, she's provided other dates in which these dollar amounts will be posting. The very first entry, 3.45 million, should post tonight at midnight. That would be on August 27th. And then there's timestamps applied to the other amounts in those texts.
13. And this one from October 25th of 18.
This is a text from Natalie Cochran to Michael Cochran where she's talking about getting off the phone with government entities, and that the audit, which was presented as a reason why none of the contracts could be paid out, she is telling him at this time that the audit is complete. There's some additional administrative stuff that needs to take place, and that all monies from all those contracts that he believed were being awarded and due will be available by Monday, October 29th.
You heard young Mr. Cochran testify about a 50 caliber contract, did you not?
I did.
This is number 14. And this is, again, a text. You recognize the phone number as to where that text is coming from?
Yes, that's Natalie Cochran's phone number.
And is that the only 50 caliber order in your investigation that you saw, or were there others?
That is the only one. This is a reference to a text, again, to Michael about that 50 caliber government contract order, where she is telling Michael that they, being whatever entity the contract was fulfilled with, want to double that 50 caliber order, and it would cost them $244 million and yield a return of $378 million.
This one from January 30th, 2019. Who is that one from at 334?
Again, this text is from Natalie Cochran to Michael Cochran. In this text, this is following the government shutdown, to put it in context. And she is telling Michael that they have all the money being resent tomorrow, and they should be available to them by Monday at the latest. And then the feds will begin sending money on Monday. This was dated January 30th of 2019. February 1st was the date that the investors had been told that the monies would be released post-government shutdown.
There's one from the 31st.
This is, again, a text from Natalie Cochran to Michael Cochran, where she is telling him that she is on the phone with Bank of America, and this is in reference to the monies that were supposedly inbound, and that's why she's talking with Bank of America.
I'm going to object on lack of personal knowledge.
All right, that's fair. Sustained.
As part of your investigation, did you download records indicating when the defendant was using her cell phone to make phone calls?
Yes.
Did you compare the text messagings with the downloads to see if, in fact, she was on the phone with the bank?
There were instances where she claimed to be on the phone and she wasn't, and there were instances where
Judge, I'm going to object. This is a broad. I withdraw that.
Okay.
Thank you.
Defendant lied.
21. What's DFAS?
DFAS is the Defense Finance Accounting Service. It's a federal government entity that deals with defense finance.
And 2 days before Michael collapsed, there's a reference to the organization you just mentioned. Who's Betsy?
Betsy was earlier referenced in testimony to Betsy Britland. Betsy was a character created by Natalie Cochran to be a government employee that she communicated with regarding government contracts on the regular. She would ask, or when asked about contracts, she had told Michael that her point of contact was Betsy Britland with DFAS or the U.S. Treasury.
That's not in the exhibit. The witness is testifying from some other unidentified documents. I object to it.
Overruled.
Go ahead.
So Betsy Britland, who did not exist, this is a reference to Natalie claiming to have spoken with Betsy regarding the contracts and the whereabouts of the award money that should be coming to the contracts. And this text is, again, to Michael Cochran.
22. And on 2-4 at 3:01. 2-4-19 at 3:01.
Again, this again is a text message from Natalie Cochran to Michael Cochran, assuring him that all 4 wire transfers and money deposits were en route and that they potentially could show up that day on February the 4th. And she references 4.8 regarding millions of dollars that should arrive in the morning and 23.8 million tomorrow, the next day at some time.
From your review of the text messages between the defendant and Michael Cochran, the defendant and Wendy Poteet, the defendant and the Davises, the defendant and Stephanie Hamilton, was there a pattern emerging there?
Yes, there was.
And was always deception to all of those parties, was it not?
Judge, now the prosecutor is testifying. I object.
Fair point.
Sustained.
The text messages that we've reviewed in summary fashion, did they indicate a pattern to you?
They did.
What is that pattern?
That Michael Cochran was being told the exact same information that the investors were being told. Those who were relying on money to be paid back to them, the information that was given to them is the exact information that was being given to Michael Cochran.
And that all derived from the defendant, correct?
Yes.
Could I have just a moment, please?
Sure.
Yes, Tim. There was also reference in the defense case to Michael utilizing the defendant's phone and sending messages as a guise that it was her sending them. Do you remember that?
Yes.
Oops, I need another marker.
This is State's Exhibit number 39, Your Honor.
All right.
Thank you. And what's been marked for identification is State's 39. Ask you if you could identify that.
You want me to identify it?
What?
Yes. This is a photograph of a text message from the cell phone of Matt McCormick. It's a text message stream between Matt McCormick and Michael Cochran.
What time is the text message from Michael Cochran?
There are 2 dates here. Do you want?
The second one.
On February 6th at 1:39 p.m., there is a text message that was sent from.
I'm going to object to this. This has nothing to do with my client's statement. This is hearsay.
We don't think so.
This is a statement between 2 third parties. One is dead, the other one is a third party.
Care to respond, Mr. Truman?
Yes, sir. This is a text from Michael Cochran's phone when all the evidence says Michael Cochran was totally unconscious and lying on a couch.
I'll allow it. Overruled. Go ahead.
This is a text message at 1:39 p.m. from Michael Cochran's phone to Matt McCormick's phone, in which he is telling Mr. McCormick that he would be available to see him in a few days, reference a firearms transaction.
From your investigation and from all the evidence to date, is there any possible way that Michael Cochran could have sent that text?
No, not at 1:39 p.m.
Why not?
We have a timestamped photograph taken by Natalie Cochran at approximately 12:30 of Michael Cochran laying on the floor at their residence. And then soon after, we have witness testimony of individuals at their house with him in his unresponsive state during that time frame.
Your Honor, at this point, the state moves into evidence. I can't remember the numbers. Is it 37, 8, and 9?
37, 38, and 39.
Please.
And I'll preserve the defense objections previously made. Are there further objections that you wish to place on the record?
Now, Your Honor, to all of which I do object.
All right. I'm going to admit States Exhibits 37, 38, and 39 over the defense objections.
Your Honor, the state has no further questions.
All right. Cross-examination, Mr. Victor.
Mr. Heinzman, the purpose of your testimony here today is to demonstrate that Michael Cochran, and this is an old story, was duped by my client, Natalie Cochran, and didn't know anything about these contracts, right?
Yes.
Now, and for that matter, the other message there that you are telling the jury about is that Natalie Cochran was involved in the illicit business of contracts. Is that right?
Yes, that's correct.
Would you agree with me, sir, that throughout this trial, as you were sitting here, we have conceded that Natalie Cochran was a bad girl and she was dealing in those federal contracts? Did we concede it or not?
Did you concede to it? I don't know who we is.
Listen carefully. Is it true that Natalie Cochran has conceded that she was involved in the fraudulent scheme?
Yes, she did.
So that shouldn't be any surprise for you when you look at all these documents. That she is involved in these transactions.
The purpose of my testimony was to illustrate that Michael Cochran was not involved in the illicit transactions.
Michael Cochran wasn't involved in it. All right. I'm going to ask you if I can do this. Looking at one of the examples. Yes. I do not recall which number it was. I think it's somewhere around 5 or 6. But you testified about this document, didn't you?
Yes, I did.
That document was telling you that on August the 30th, and I presume 2018, $1.2 million was going to be posted, right? See it there?
On August 30th, yes.
Yeah. Posted in the account of Mr. and Mrs. Cochran, right?
Yes.
Then on September the 4th, I'm sorry, the 3rd, $724,000 was going to be posted. May not be the 3rd because it's going to be a holiday, but it was going to be posted in the Cochran's account, right?
Yes.
And then $2.56 million next Friday was going to be posted in their account, right?
Yes.
Well, comes August 28th, no money in the account, right?
Correct.
Comes August 29th, no money in the account.
Correct.
Comes the end of September, no money in the account, right? Right?
Yes.
Yes. Well, that $2.6 million next Friday, so that's probably sometime, I don't know, sometime at the beginning of September, right? No $2.6 million coming.
Correct.
And Mr. Cochran doesn't know that? He is waiting for about $4 million, right? Right?
The last date put out on these is December, so between August 27th and December, it was over $300 million that he was
I
told
asked
was
you
due.
about these numbers. 300,000, $1.2 million, 724,000 dollars, $2.6 million. There's nothing about December there, is there?
December 21st on the next one down. 12/21, $131 million on 12/21.
I didn't ask you about that, sir. I asked you about the top,
Okay,
the exhibit. There's about $4 million coming to Michael Cochran, to his account, right?
to the business, yes.
To the business where Michael Cochran is a minority owner, right?
No,
No? To the business where he has a joint account, right? Yes, sir? Yes or no?
yes,
Yes. $4 million coming to my account, and I don't know anything about it?
that is correct.
And-
Well, he knows what's been told to him here
Okay.
about the
Well,
$4 million.
Fine. Then let me ask you this. We are now at the beginning of October. That $4 million didn't materialize itself. He is not asking questions, is he?
He absolutely is. The defendant had
is?
produced an audit
Show me
ruse,
in any of these documents, sir.
an audit ruse.
Show me any of these documents, these exhibits. When he is asking any questions about where is that $4 million?
We have.
Where is that $4 million? Show me any of these documents here that were admitted into the evidence. Not some stuff about we did our investigation. Show me in any of these documents.
If you'll hand the documents back, I'll review them to see if I can find that.
You can review them all you want.
But I know that throughout the text messages that were reviewed, 1,224 pages of text messages were
I don't care about this.
numerous times that Mr. Cochran
Show the
asked
jury.
where the
Mr.
money
Heinzman,
was at.
Mr. Heinzman, there's no question pending. I'm asking you to show this jury from these documents that Michael doesn't know, that Michael somehow is not surprised that the $4 million that was supposed to come to him at the beginning of September is not there. Show me.
He had been
Show
told
the
it
jury.
wasn't coming because of an audit.
No, sir. You look at these documents, show me if there is anything in these documents that indicate that Michael Cochran is or is not surprised by not getting $4 million.
Your Honor, do me take the time to review all these documents? And
Well, if you can, go ahead, Mr. Hoffman.
I'll move quickly.
All right.
And I'm looking specifically for where is that $4 million that was supposed to come in September?
Would you restate your question?
Well, show me in any of these documents when Michael Cochran is asking Natalie, or anybody for that matter, where is that $4 million, or, well, 300,000, 3.4, well, there's more than that. 300,000, $1.2 million, $724,000, and $2.56 million. Where is it? It was supposed to be deposited. Now it's September, it's October, it's November. Where on earth is that money? Show me any of these documents indicating his inquiry about that.
Okay. On page 19, he's referencing the 1.6 million, having to wait for that. On
Okay.
page 20, when she says she's on the phone with Bank of America, he's asking, are we 1,000%? Because she's told him at that point that the money is at Bank of America.
Okay?
On page 21, he says, this is February 4th, the day that 3 days after he expected the money, he tells her that the money isn't there. She provides additional excuses for that. And then on page 22, dated February 4th again, she's telling him that the 88 million and 297 million will possibly show up today.
Not she's telling him.
4.8 million in the morning and 23.8 tomorrow. Again, another delay, and his response is shit.
All right. Okay. Show me.
You want me to go through the rest of the documents?
Hold on. Show me when there is going to be $108 million to be deposited in the account on October the 12th.
It's right there on August 27th on the text that's being provided.
And $131 million to be deposited in November and in December.
Yes, it's
And-
right there on the text.
And he doesn't know that this money ain't there?
No, he believes this money is coming. What's significant about August 27th?
No, I didn't ask you. You seriously?
I can explain.
Hold on, sir.
Okay.
Are you seriously contending before this jury that he doesn't know that that $239 million is not there?
I'm telling
Yes or
this
no,
jury
sir?
that
Yes
Michael
or no?
Cochran does not know.
Yes or
because
no,
he
Your
believes
Honor?
that money is coming.
Your Honor, I'm sorry. It's a yes or no?
Well, he's trying to explain, and I think we should let the witness explain his answer. Go ahead, Mr. Hansman.
Michael Cochran has been led to believe that all this money is coming to their accounts for government contracts, and it never comes.
And I presume that in September, October, November, December, and January, he lives in the same household as Natalie Cochran, right?
He does, yes.
He certainly doesn't live on another planet. He can talk to Natalie Cochran about these contracts on a daily basis. He can talk to her, can he not?
Yeah, he does.
And he does. And he, on August 20, whatever, September, honey, where's that $8 million or $4 million? And she's lying to him, right? Is that your testimony?
And she says, we're getting hit with an audit. Can you believe it?
On September 5th, she's telling him, oh, no, that money is coming, right? On September 6th, 7th, 8th, 30th, October, he is somehow duped by it, and he's so blind to it that he will not ask his wife, where is $238 million? And he naively and blindly believes that this money is going to be there and it ain't there? Is that what you're testifying to, Detective?
Absolutely.
All right. Show me. There is nothing in these documents that talks about Michael's computer. Is there? Michael
not in these documents.
Arranging for these contracts on his computer as he's sitting in the bedroom while Natalie is watching TV and the kid is between them. Those documents don't deal with any computer operations of Michael Cochran, right?
No, they do not.
Okay. Those documents did not deal with any personal contacts that Michael Cochran had with the investors, including his own mother. Correct?
These documents do not.
These documents do not deal with any checks that he wrote, as we saw in some of the exhibits here,
on behalf of the companies, correct?
Correct.
For either services rendered or for consulting services, etc., right? These
Correct.
documents don't show that. These documents don't, these documents do not address any issues that, well, the detectives are coming and, you know, maybe they should talk to the kids. Is there anything about that anywhere?
No, that wouldn't be anything like that.
All right. These documents, of course, do not deal, again, in the same old story, with the lifestyle of the Cochrans, right?
These documents do not.
Honey, I'm taking you to Paris and I'm gonna get you a Louis Vuitton bag for God only knows how many thousands of dollars because we have somebody else's money to live high on a hog, right? These documents don't deal with this, do they?
Not that depiction, no.
No, not that depiction. Well, they don't talk about any of the wealth that the Cochrans, plural, have acquired through the illegal schemes and enjoyed for a long time, right?
These documents do not.
These documents don't deal with anything about Michael Cochran's health. Honey, I feel bad today, I'm declining, or anything of that nature.
There are references to him being stressed because of the lack of money.
He is stressed because he doesn't know.
In these documents I'm referring to.
He's like in a National Enquirer. We want to know, right? He wants to know, right?
He wants to know where the money is that they've earned
wants to know.
through what he believed was legitimately awarded government contracts.
Right. And yet he goes to a boat sale and buys himself 2 boats at the same time, right?
I don't know if he went to a boat sale. I know that he did purchase ATVs, boats, vehicles,
Right.
things of that nature that both he and his wife picked out based on text messages we read, or by her encouragement to make purchases because she had led him to believe that they had all
Sure,
this
she let him
wealth.
to believe. And you truly believe it.
Absolutely.
All right. These documents do not show, these documents that deal with Natalie only, not Michael, whether he was copied on them. Do they?
So would you ask that again?
No, you look at any of these documents where Natalie is talking to Miss Petite or Chris Davis, where Mr. Cochran is not involved. Is there any indication that he is copied on those conversations?
Some of them, yes.
Yeah. So some of this he knows, right?
Some of it, but
Yeah.
not in this context that you're framing it.
Not in this context, of course. Okay. Now, when he talks on some of those messages, the jury will probably see that those conversations take place after Michael's death, right?
Yes.
So he cannot contract anything, Mr. Heinzman, because unfortunately he's passed away, right? Right?
Yes.
And Natalie Cochran is continuing the scheme that she was involved in, but it has nothing to do with what Michael knew and what he didn't know because he's dead. Right?
No, it supports the fact that it was her scheme because she continued it on.
Well, one of those exhibits, Michael asked, no, 16. Michael asked directly to pull out $9,500. From where?
From their personal account
To do what with it?
to have some cash on hand.
And that $9,500 came from where? They didn't have any income, independent income. That must have come from the investors, right?
That or rescue loans.
Well, is it possible that since they have no income, independent income, you testified that Natalie wasn't working as a pharmacist anymore, and Michael's job was an IT man, not really defined, that he's pulling $9,500 in cash that must have come from the investors, right?
Yes.
So he pulls $9,500 that he considers money earned, right?
From previous
If
contracts,
he,
yes.
if he believes that, if he's so scrupulously honest, well, he must believe that this is the money that they've already earned on those contracts, right?
Right. He's not aware that they're illicit proceeds. He thinks they're legitimate proceeds.
Right.
Right.
What does $9,500 tell you as an investigator of money laundering?
Well, that,
Cash. I'm going to ask $9,500 cash. What does that tell you? You're the expert here on money laundering.
sure. In this context, it means nothing. In the context that you're framing it, it references currency transaction reports. Those are a federal requirement under the Bank Secrecy Act.
Well, let me ask you
Where-
this. Let me ask you this. Every,
Yeah.
well, I'll ask a very specific question.
Well, the witness should be permitted to answer. Go
Explain
ahead,
that
Mr.
$10,000
Oscar.
cash.
The Bank Secrecy Act requires financial institutions to file what's called a currency transaction report for any transaction involving $10,000 of U.S. currency, that'd be cash or coin, in or out of a financial institution. It is a derivative of the Patriot Act and the War on Terrorism, so they want to track large amounts of cash. So if a withdrawal from a financial institution were to occur above $10,000, the bank would be required to complete a currency transaction report and document that transaction. In this case, however,
Well, I'm
the
sorry.
Cochrans
Now
had
let me,
cash
I'm
inside
sorry.
a
I'm
safe.
sorry, Your Honor.
Okay,
Now the question is this.
fair enough. He's answered the question. Go ahead, Mr. Victor.
$9,500 in cash is obviously under 10 grand, right?
It is.
And he withdraws that amount of money in cash, right?
Yes.
Would you agree with me that he does that for the purpose to avoid the $10,000 money reporting necessity?
No, I would not.
No?
That's not illegal. It's not an illegal act. It's when that is anything 10,000 or more
Right.
is taken out in multiple increments over a short period of time. That would then trigger what's called a suspicious activity report
Right.
with the bank that ties back into the currency transaction report.
And
So
that's
that
why-
that amount alone is not illegal.
And that's why he's taking $9,500 rather than 10,000, because he would have to report it to the IRS.
Your Honor, that's speculation. There's no way the
Wow.
witness could read the
Sustain.
defendant.
All right, that's fine. What about those income tax returns that the parties filed jointly?
Those were prepared by Natalie Cochran. They were false documents.
They were false documents.
Yes.
And he signed off on them.
There was no signature by Michael on the documents.
For 2017,
No, there was not.
2018,
No, there was not.
2019,
No, there was not.
and you're telling this court that she filed taxes and he didn't know anything about the income tax returns.
That's correct.
So he himself broke the law by not filing income tax.
If he had known what was being filed,
If he had known, he would have filed taxes.
no, if he had known what was being filed.
Okay. So he didn't have to sign the income tax return because his income was zero? Why didn't he have to file income tax return with Natalie?
I'm not saying he didn't have to.
Why didn't he sign those?
Because they're done electronically now, you don't even have to sign them. One person could fill them out and file them electronically. He doesn't have to sign it. Now, the law requires that all tax preparers review their documents that they're filing, but
And he reviewed them, and he had absolutely no idea what Natalie was doing with the taxes, and with the bank losses, and with, well, the business losses, the business gains, et cetera, et cetera.
I have no idea if he reviewed them. If he had, he would further believe that he had made an extraordinary amount of money on government contracts.
Show me here any income tax return that lists about $4 million by the Cochrans. Can you do that? Can you show this jury?
No, I cannot. I don't have the discovery files and records with me to break out the tax returns that we did recover.
From your thorough investigation of this case, because you said that several times, was there ever an income tax return filed by the Cochrans that would list $239 million? Can you tell the jury that?
I know that there are tax documents that were given as ruses to get bank loans.
From your memory, Mr. Heinzman.
But I cannot say if that figure that Mr. Victor has given me matches those documents.
$239 million, would that raise some red flags if you ever saw an income tax return from a small West Virginia company filed with the Internal Revenue Service? Would that cause you to pause and consider that?
In what context?
Well, somebody's making $239 million from a business and files that income tax return. I would like to know the details of it.
Are you talking about the IRS would want to know the details, or?
Well, you were investigating their.
I've already answered that question. If I saw that, it's another prop. It's a ruse. It's not unsubstantiated by financial records, income records, state databases, federal databases. They would just, to me, if I saw that,
So you have
it would
no
be another
idea.
prop.
So you have no idea as you sit here today to tell this jury how much money Mr. and Mrs. Cochran were making and how much money they were reporting. True? As you sit here right now. Can you or can you not?
It's a very broad question.
Well, how much money did they make in 2018? Can you tell this jury whether they made millions or whether they made a couple of $1,000s here and there?
2018.
Yeah.
Are we talking about legal income or illegal income?
Income tax return. You remember?
The income tax returns that we reviewed were submitted not to the IRS because that would have got red flags, but to people that they wanted to borrow money for to demonstrate the value of the company.
So now you're telling us that Natalie didn't file income tax in 2018?
My recollection was that there had not been income taxes. No, let me correct that. The income tax documents that we recovered had been doctored to show greater income because they were used for other purposes. The actual income tax that was filed, which presumably would have been legitimate, we did not review.
I see. Now, okay, if I may have a second. I don't think I have any more questions of this witness.
All right, redirect Mr. Truman.
Nothing from the state, Your Honor. Thank you.
Very well. Mr. Huntsman, you may step down, sir.
Thank you, Your Honor. Copies or exhibits?
I think we've got the exhibits spread all around. Let's make sure that we collect them. Give everything to the clerk and she can sort them.
We've got them, Your Honor.
Okay.
It's part of, it fell off.
Part of this one?
It fell off.
If it's a copy, no, I don't need it.
This fell off of here. That's part of 38.
Let me inquire, Mr. Truman, will there be further witnesses in rebuttal?
Your Honor, the state rests.
All right, will the defense have any rebuttal evidence? Certainly.
The defense rests likewise.
All right, members of the jury, you've heard it from the lawyers themselves. This is the completion of all the evidence to be presented before you. The next phase of the case will be the instructions of the law by the court. I will read the instructions to you. That's one thing that we have been working on to try to get a leg up and get ahead of the game, so to speak. We've pretty much settled on the instructions, and so we should be ready to go this afternoon. We've worked into the traditional lunch hour, and so be back in your jury room at 1:30. That'll give you a little extra time for lunch. We will commence hopefully with instructions at that time and argument of counsel thereafter. So although we are winding down and although we have completed the presentation of the evidence before you, the case is not over. It would be improper for you to discuss the case among yourselves or with anyone else at this time. Please enjoy your lunch. Do not do any research. Do not read anything online in the newspaper or on TV. And be back, please, in your jury room a little bit before 1:30. You may go with the bailiff now to your jury room. All right, Mr. Truman, I'm hopeful that you can have a working lunch and maybe go through the charge while you eat your sandwich.
I'll take care of, yes, I'm on page 8.
I
Okay.
have them done.
All right, thank you.
So far, there's only been a couple little things to check on.
All right. Maybe we can come back at 1:15, so we'll have 15 minutes to make any corrections.
I think that should do it.
All right, and then
From a
we
safe
can
perspective.
start out on time. I don't want to delay the jury anymore if we can help it. Is there anything further on behalf of the defense that we need to discuss?
No, Your Honor, thank you.
All right, we'll break for lunch, and if you can, be back at 1:15 so we can take up the instructions further. All right, have you received a copy of the court's charge? Here it is. And I've realized that one thing we failed to discuss was the jury verdict form. We have one, but I don't know that it's been approved by the other side.
They had it.
I think we did have some corrections on it, but I'm having trouble.
It's pretty simple and straightforward. Thank you for the list, Angie.
That exhibit list is updated to the final.
Thank you so much.
It's been approved by the defense.
All right. Is this the same version you submitted earlier, or is it a revised version?
The one submitted this morning is that one. The original one I submitted a couple weeks ago was
Okay.
that one has been revised. But this one has been approved by and it includes the lesser included.
Okay, I'm going to have this stapled. You may have to take it in the other office to staple it.
Your Honor,
Yes.
I have a minor point to discuss. May we approach? Well, since the jury isn't here.
Not here.
I was looking over the identification of the state's exhibits and the defendant's exhibits, and I believe might be a little confusion or clerical error in item number 10 and item 16. It reads an empty vial of methylprednisolone acetate injection. It's not the injection itself. It should read empty vial of injectable methylprednisolone acetate.
Okay.
I took that right off the label.
She said she took it right off the label.
Fine, it's a minor point anyway.
Okay. All right. Can the defense approve the court's charge?
Final stages.
Okay.
Oh, yeah.
Okay. Check this. I think this is an older version. I don't think that's the most recent one. I think this is the most recent one. You don't want to get confused. Okay. All right, let me ask counsel, how much time do you require or request for argument?
Your Honor, we'll defer to the defense.
I don't know. The state has the burden of proof. Maybe the state can.
20 minutes?
Are we talking half an hour? Are we talking
Half an hour?
What do you guys need?
No, I don't.
Hey, want to do that 45
Okay,
minutes?
45 minutes.
45 minutes?
Yes, Your Honor.
Okay, will you be doing the closing, Ms. Aker?
Yes, I will, Your Honor.
Okay, how do you want to divide your time?
35, 30, 30, 15. What? How, we have 40?
35 for closing and 10 for rebuttal, Your Honor.
Do you want a discrete 1-minute warning
I would appreciate that, Your Honor. Thank you.
on both ends?
Please.
That would give the defense the full 45 minutes if you wish to take it. Do you wish a 1-minute warning, 2 minutes, or what? This is
2-minute warning is fine.
Pardon?
2-minute warning is
2
fine. Your
minutes.
Honor.
All right, here's the final question I have for you. It's going to take me a little while to read these instructions because it's 18 pages. Do you want to take a brief recess between the court charge and the closing arguments, or do you wish to go on through? It's up to you.
Judge, the only thing about the instructions, I thought we were placing the involuntary manslaughter before the instructions dealing with malice.
I thought that's what we did.
Yeah, I thought so too, but it's not the case.
Judge, I think
Page
that is what we proposed.
Okay.
It would just be a matter of cutting and pasting page 10, where it starts with the definition, and moving it before the discussion of malice on page 9.
Okay. I'm going to ask you two to go with Ms. Brown Bailey and assist her so that you can set it forth appropriately. Oh, okay. Oh, okay. Yes, very legible. Thank you. Even better than typewritten. Of the court's charge, I see that we have switched the elements for involuntary manslaughter with the definitions of malice. Is that correct, counsel?
Correct, Your Honor.
Yes, Your Honor.
And we haven't changed the wording of anything. We've simply moved those segments around as indicated.
It was a cut and paste. Yes, sir.
Yes, Your Honor.
All right. That's agreeable, certainly, with the court. That's what we discussed. One more thing. Do either of you wish to have the podium set up in front of the jury box?
Yes, Your Honor.
All right. I'll ask the bailiff to do that, please.
And Your Honor, while we're doing that, after some reflection, I'm thinking I might need a little more time for closing. If we could have an hour total, I won't need that long, but I think mine will probably run about 45 minutes on its own.
All right. So you'd like to have an hour altogether?
Yes, Your Honor.
And how do you want to divide that?
45 and 15.
Sure.
45 and 15, Your Honor.
You still would like to have the 1 minute warning?
Yes, please.
And that would afford to Mr. Victor a full 60 minutes. Is that agreeable?
Yes, sir.
With the 2 minute warning?
Yes, sir.
All right. Are we ready for the jury?
Yes, sir.
Bring in the jury, please.
And Your Honor, the state does think that it would be appropriate to take a break between the charge and beginning of closings, given the length of the closings.
Okay. I think that's probably a good idea. Members of the jury, the next phase or stage of this case, as I touched on earlier, is the instruction of the law by the court. I can tell you that this is a very boring and tedious part of any trial. And perhaps some of you who have served as jurors before know that very fact. Sadly, you must pay strict attention to what I tell you. Your oath requires you to apply the law that I will state to you to the facts you determine from the evidence. So this is a very important stage or part of any trial. Members of the jury, you have now heard and seen all of the evidence in this case. You are the sole judges of that evidence and the facts that it establishes. It is your sworn duty to determine and base your verdict only upon that evidence. In doing so, do not be influenced by sympathy, anger, passion, prejudice, or public sentiment. It is now my duty to inform you about the law that applies to this case. You have no right or privilege to disregard these instructions or to form a different opinion about what the applicable law is or should be. All of these instructions are important. Do not pick out one part and ignore other parts. You are to draw no inference from the order or manner in which they are given, and they are to be considered by you in their entirety as a whole. The indictment in this case is merely an accusation, and it is not any evidence of guilt. The burden is on the state to prove the guilt of the defendant beyond a reasonable doubt. The defendant is not required to prove her innocence. Our law presumes a defendant to be innocent of crime. So the defendant, although accused, begins the trial with a clean slate with no evidence against her. And the law permits nothing but legal evidence to be considered in support of any accusation. So you see, the presumption of innocence alone is sufficient to acquit the defendant. You must determine the facts of this case from the evidence only, that is, from the testimony of witnesses and exhibits. Disregard completely testimony to which an objection was sustained or exhibits ordered stricken out of the record. Absolutely nothing that I have said or done during this trial is to be considered by you as evidence or as any indication of an opinion concerning the weight of the evidence, the credibility of the witnesses, or the guilt or innocence of this defendant. Nothing that I, as judge, said or did at any time during this trial is to be considered by you as evidence of any fact or as an indication of any opinion as to any fact or evidence, or as a measure of the credibility or truthfulness of any witness who testified, or as to the weight you should give to such testimony, or as to what your verdict should be in this case. For you are the sole judges of such matters, and I am only the judge as to the applicable law. The evidence from which you are to determine and base your verdict consists of the sworn testimony of all of the witnesses, regardless of which side called them as witnesses and whether their testimony occurred on direct or cross-examination. The exhibits that were received into evidence, regardless of who introduced them into evidence. Any facts which I have told you were agreed upon by stipulation or otherwise, and any fact which I took judicial notice of. However, if you do not agree with that fact, you are not bound to accept it. Members of the jury, there are two basic kinds of evidence, direct and circumstantial. Direct evidence is testimony as to what a witness saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is the evidence of a fact from which another fact, not directly testified about, can be inferred or found. Both of these kinds of evidence may be considered, and it is for you to determine and decide whether or not a fact has been proven by circumstantial evidence by considering all of the evidence in light of reason, common sense, and experience. There is no quantitative difference between direct and circumstantial evidence. The following elements are not evidence, ladies and gentlemen, and you are not to consider them as evidence for any purpose whatsoever. Anything that any of you have seen or heard outside of the courtroom or when court was not in session. Do not consider or be influenced by any testimony or evidence which has been excluded and not put into evidence, and do not consider or be influenced by any testimony, evidence, or any other fact or subject that I instructed you to disregard and not to consider as evidence. If during the trial I instructed you to consider certain testimony, evidence, or facts only for a particular or limited purpose, you are to continue to do so, and must consider such matters only in that manner and for that limited purpose. Do not be influenced by or draw any inference from any objections that were made by the lawyers during this trial or my rulings upon such objections, for such matters are not evidence. As I have explained to you throughout this trial, statements or arguments made by the lawyers are not evidence and are not to be considered by you as evidence, for the lawyers were not and are not witnesses. What they said to you in their opening statements, or what they will say to you in their final closing arguments or at other times, were and are made to aid you in following, determining, and interpreting the evidence as it relates to the issues before you and their respective sides of this case. While you must carefully consider the testimony of each and every witness and not disregard or overlook any testimony, witness, or evidence, the jury is the final judge of the credibility of the witnesses and the weight of the evidence. The number of witnesses testifying on one side or the other of an issue is not the only test of weight and credibility. If you feel that the evidence justifies it, you may believe one witness over a number of witnesses testifying differently. The test is how truthful is the witness and how convincing is the testimony in light of all of the evidence and circumstances shown. As jurors, you are also entitled to draw reasonable inferences and make reasonable deductions from any of the testimony or other evidence as you come to believe are justified in the light of reason, common sense, and experience. If you come to believe that any witness did not tell the truth about any material fact after carefully weighing and considering such testimony, you may disregard it or any part of it, or give to it or to any part of it such weight and credit you determine it deserves. In weighing and crediting the testimony of any witness, you may consider the good or bad memory of the witness, the interest of the witness in the outcome of the trial, the relationship of the witness to the parties involved in the case or to other witnesses, the attitude and manner of testifying of the witness, the opportunity and means or the lack of opportunity and means of the witness to learn and to have knowledge of the matters about which he or she have testified, the reasonableness or unreasonableness of the testimony of the witness, the intelligence of the witness, the appearance of bias or hostility or friendliness or unfriendliness of the witness to the parties involved in the case or to any other witness, and any contradictory acts or statements of any witness that you determine were done or made that served to contradict the testimony of such witness in court. From all such factors and considerations that appear from all the evidence and circumstances shown in the case, you are to evaluate the testimony of all of the witnesses and the weight to be given to their testimony and determine the credit you believe it is entitled to receive. In this case, you have heard testimony by witnesses who were presented as experts, who by knowledge, skill, experience, training, or education had acquired scientific, technical, or specialized knowledge in the field or area about which he or she has testified. As an expert, he or she is therefore entitled to express an opinion upon matters within his or her field or specialized knowledge and to state the reasons for an opinion. Expert testimony is to be considered and evaluated as you would the testimony of any other witness. You may accept or reject it in whole or in part, or give to it or any part of it such credit and weight you come to believe it deserves. In evaluating expert testimony, you should consider the knowledge, skill, experience, training, and education of the expert and the basis and reasons given for his or her opinion in light of all other testimony and evidence in this case. The court instructs the jury that evidence of other crimes, wrongs, or of acts by the accused is not to be considered to prove her character in order to show that she acted in conformity therewith. However, the jury may consider such evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, identity, and absence of mistake or accident as to the crimes charged. This court has taken judicial notice of court documents generated by the United States District Court, Southern District of West Virginia. That is, the court has taken as fact that the litigation in the United States District Court, Southern District of West Virginia, occurred based upon the determination of sources whose accuracy cannot reasonably be questioned. You are instructed, however, that you may or may not accept that fact as conclusive. The offense charged in the indictment in this case is murder of the first degree. You may return one of two verdicts pertaining to murder of the first degree under the indictment. They are 1, guilty, and 2, not guilty. Murder of the first degree is any felonious, willful, malicious, deliberate, premeditated killing of another person. Murder of the first degree consists of an intentional, deliberate, and premeditated killing, which means that the killing is done after a period of time for prior consideration. The duration of that period cannot be arbitrarily fixed. The time in which to form a deliberate and premeditated design varies, as the minds and temperaments of people differ, and according to the circumstances in which they may be placed. Any interval of time between the forming of the intent to kill and the execution of that intent, which is of sufficient duration for the defendant to be fully conscious of what she intended, is sufficient to prove a deliberate and premeditated killing and to support a conviction for first-degree murder. Before the defendant can be convicted of murder of the first degree, the state of West Virginia must prove to the satisfaction of the jury beyond a reasonable doubt that 1, the defendant Natalie Page Cochran, 2, in Raleigh County, West Virginia, 3, on or about the 11th day of February 2019, 4, feloniously, willfully, maliciously, deliberately, and unlawfully and premeditatedly slayed, killed, and murdered 5, Michael Cochran. After impartially considering, weighing, and comparing all of the evidence, if the jury and each member of the jury is convinced beyond a reasonable doubt of the truth of the charge as to each of these elements of murder of the first degree, you may find Natalie Page Cochran guilty of murder of the first degree as charged in the indictment. If the jury and each member of the jury has a reasonable doubt of the truth of the charge as to any one or more of the elements of murder of the first degree, you shall find the defendant Natalie Page Cochran not guilty. Involuntary manslaughter is committed when a person caused the unintentional death of another person. This court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is the main element of involuntary manslaughter. A person is guilty of involuntary manslaughter when a person commits an act in a reckless or grossly negligent manner and unintentionally causes the death of another person. Therefore, in order to find the defendant, Natalie Page Cochran, guilty of the offense of involuntary manslaughter, the state of West Virginia must overcome the presumption of innocence and prove beyond a reasonable doubt each and every one of the following elements. 1, that the defendant, Natalie Page Cochran, 2, on the 11th day of February 2019, 3, in Raleigh County, West Virginia, 4, unintentionally, 5, caused the death, 6, of Michael Cochran, and 7, against the peace and dignity of the state. If each and every juror is not convinced beyond a reasonable doubt that the state of West Virginia proved beyond a reasonable doubt each and every element of the offense of involuntary manslaughter, the jury must find the defendant, Natalie Page Cochran, not guilty. Malice is a subjective state of mind of the defendant. It may be proven by evidence of circumstances surrounding the crime, such as words or conduct of the defendant before, during, and after the event, or evidence of ill will or a source of antagonism between the defendant and the deceased. Also, malice may be inferred from a deliberate cruel act, indicating a heart disregarding social duty and fatally bent on mischief. Malice and intent also may be inferred from the defendant's intentional use of a deadly weapon under circumstances which the jury does not believe gave her legal excuse, justification, or provocation for such conduct. Malice may be expressed to include not only anger, hatred, and revenge, but other unjustifiable motives, and may be inferred by you from all of the evidence in this case if you find such inferences reasonable from the facts and circumstances in this case which have been proven to your satisfaction beyond a reasonable doubt. Malice may be also inferred from any deliberate and cruel act done by the defendant without any reasonable provocation or excuse, however sudden. Malice is not confined to ill will toward any one particular person, but malice is every evil design in general. It is not necessary that malice must have existed for any particular length of time, and it may first exist at the time of the killing or at any previous time. As a defendant is presumed innocent of the charges brought against her, she does not have to prove herself innocent and is not required to call any witness or produce any evidence. She is also not required to take the witness stand and testify, for she has a constitutional right not to do so. The fact that the defendant did not testify is not any evidence against her, and you shall not consider that she did not testify or draw any inference from that fact as to the guilt or innocence of the charges brought against her. You must entirely disregard it and not discuss it. The court reminds the jury that throughout this trial, the state maintains the burden of proving the defendant's guilt of the crimes charged beyond a reasonable doubt. From time to time during this trial, it was necessary for me to talk with the attorneys out of the hearing of the jury, whether by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Most of these conferences involve determinations as to whether evidence is admissible under the rules of evidence. It is appropriate to take these matters up outside the presence of the jury. If I concluded that a more prolonged discussion was necessary, I may have excused you from the courtroom. You've heard evidence concerning alleged conduct or other acts of the defendant, Natalie Cochran, which are not charged in the indictment. You are instructed that such evidence is not admitted as proof of the defendant's guilt on the present charges. This evidence is admitted for a limited purpose only, and it may be considered by you in deciding whether a given issue or element relevant to the present charge has been proven. Accordingly, this evidence may be considered by you only for the limited purpose for which it has been admitted. In this instance, the evidence of the defendant, Natalie Cochran, alleged criminal acts of the, quote, Ponzi scheme, unquote, may be considered only for the purpose of determining whether the state of West Virginia has established the motive to perpetuate the first-degree murder. You are instructed that upon the trial of this case, if reasonable doubt of any fact necessary to establish the guilt of Natalie Cochran, the defendant, as charged in the indictment, be raised by the evidence or lack of evidence, such doubt is decisive, and the jury must acquit the defendant, Natalie Cochran. You do not have to believe that the defendant, Natalie Cochran, is innocent of the charges against her in order to find a verdict of not guilty. Your verdict of not guilty only means that the state of West Virginia has failed to prove to you the guilt of the defendant, Natalie Cochran, beyond a reasonable doubt. The jury is instructed that the mere presence of the defendant at the place of the alleged crime or crimes does not in and of itself indicate participation of the defendant in the criminal act or acts. The defendant's mere presence at the scene of a crime or mere knowledge that a crime is being committed is not sufficient to establish that the defendant committed the crime charged in the indictment unless you find that the defendant was a participant and not merely a knowing spectator. The state of West Virginia must demonstrate to the jury beyond a reasonable doubt a nexus between the defendant's presence at the scene of the crime or crimes at the time or times of the alleged crime or crimes and her participation in the criminal act or acts. In relation to any and all charges contained in the indictment in this case, if each and every member of the jury is not convinced beyond a reasonable doubt as to each and every element of the offenses charged, the jury must find the defendant not guilty. If the jury has a reasonable doubt as to the grade of the offense of which the defendant, Natalie Page Cochran, may be guilty, the jury shall resolve that doubt in favor of the defendant, Natalie Page Cochran, and find her guilty of the lower grade. If the jury has a reasonable doubt as to whether the defendant, Natalie Page Cochran, is guilty of any offense, the jury must resolve that doubt in favor of the defendant, Natalie Page Cochran, and find the defendant not guilty. Evidence relating to any statement alleged to have been made by the defendant, Natalie Page Cochran, outside the court and after a crime has been committed should be considered by the jury with caution and weighed with great care. All such statements should be disregarded entirely unless the other evidence in the case convinces the jury beyond a reasonable doubt that the statement was made knowingly and voluntarily. In determining whether any alleged statement alleged to have been made by the defendant, Natalie Page Cochran, outside of court after a crime has been committed was knowingly and voluntarily made, the jury should consider the age, training, education, occupation, and physical and mental condition of the defendant, Natalie Page Cochran, and all other circumstances surrounding the making of the alleged statement. The jury may give the statement such weight as the jury finds it deserves under the circumstances. The test for the burden of proof in a criminal case is beyond a reasonable doubt. This means that after considering all of the evidence, if you have a reasonable doubt of the accused's guilt, then you must find her not guilty. You must always remember there is no burden upon an accused to prove anything. It is the state who has the burden to prove the accused's guilt. One never has to prove one's innocence. You must give an accused person the benefit of any reasonable doubt you may have from the evidence or from the lack of evidence, but remember the doubt must be a reasonable one. This means that it must be founded on reason and should be explainable, not a dreamed up or fancied one with no basis. The test is not beyond a shadow of a doubt, nor beyond all possible doubt. It is beyond reasonable doubt. After hearing and considering all of the evidence, you are satisfied that based upon the evidence you have in your heart an abiding conviction of the truth of the charge, then you are convinced beyond a reasonable doubt. It is your duty in this case to apply the law as given to you as a whole in the form of these instructions to all of the evidence in this case. In that regard, the court has instructed you on your role in determining the credibility of a witness and the weight of the evidence. The court has instructed you on the difference between direct evidence of a fact to be proven and circumstantial evidence of a fact to be proven. You must never convict a person unless the facts justify it, but you should not shirk your duty when the facts do justify a conviction. You must require that the state meet its burden of proof, but you must not make the state's burden an impossible one. The burden is always on the state to prove guilt beyond a reasonable doubt. This burden never shifts to the defendant, for the law never imposes upon a defendant in a criminal case the duty of calling any witnesses or producing any evidence. A defendant is never to be convicted upon mere suspicion or conjecture. To convict, you must be satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. So if the jury has, after a careful and impartial consideration of all of the evidence, a reasonable doubt that the defendant is guilty of the charges, it must acquit. If the jury views the evidence in the case as reasonably permitting either of two conclusions, one of innocence and the other of guilt, the jury should, of course, adopt the conclusion of innocence. In the trial of a criminal case by a jury, the law contemplates the concurrence of 12 minds and any verdict returned, whether guilty or not guilty. Each individual juror must be satisfied beyond a reasonable doubt of the defendant's guilt before he or she can consent to a verdict of guilty. If each and every individual juror has a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. The jury is no place for unreasonable pride of opinion or for stubbornness. While no juror should yield a conscientious opinion deliberately formed after a full and fair investigation of the case, nevertheless it is the duty of every juror to consider all of the evidence of the case, the instructions of the court, the arguments of counsel, and to discuss the evidence with the other jurors with an open mind and to give careful consideration of the views of fellow jurors, and if it can be done without sacrificing conscientious conviction, agree upon a verdict. Ladies and gentlemen, that concludes the reading to you of the court's charge or the instructions of the law. We're going to take a very brief recess so that the attorneys can collect their thoughts, and you will hear shortly from them in terms of their closing remarks or closing argument. I warn you, we are not yet to the deliberation phase of this case. After the lawyers deliver their closing arguments, you'll be able to fully and fairly deliberate on this case. But at this juncture, you cannot discuss the case among yourselves or with anyone else. I contemplate perhaps a 5-minute break, and you will return to the courtroom and we will proceed with closing remarks. You may go with the bailiff now briefly to your jury room. We'll take a bathroom break for 5 minutes. All right, are there any matters that we need to raise and discuss out of the presence of the jury at this time?
There's one that's been brought up by the defense, Your Honor, and that is the indictment says February 6th. The
Indictment actually says February the 11th.
That's what I thought it said too, but I was told by the defendant and I didn't have a copy.
Well, I've got a copy because I heard the same suggestion that you did, and it says on or about the 11th day of February 2019.
Blaine Selden, he came up with
Go
that.
ahead. Just the point I brought up, and it's probably too late to address it. The murder says February 11th. The alleged act occurred on February 6th. That's when the alleged act occurred. The death of Cochran occurred on February 11th. I don't know what we can do about it or anything of that nature.
It's on or about. There's nothing to do about it.
I don't think there is anything we can. Oh, we didn't have a court reporter.
Well,
Uh-oh.
I
You
thought
want
you
a
were
record
down
of
there,
that, Gavin?
Joanne. I'm sorry.
no, you didn't do anything wrong.
You didn't do anything wrong. All right, I think we can go forward. We can change the instructions, and I can read them all over again, but everybody's moaning and groaning, and nobody wants to hear that.
With a big sign that says, "This is Selden's fault."
Right.
Just for the sake of the record, I brought to the court's attention, the indictment says that the murder occurred on or about February 11th. I just brought to the attention of the court, the alleged act occurred on February 6th. The passing of the deceased occurred on February 11th. I don't know how that impacts anything.
I don't think it impacts anything. It's on or about. No objection was raised. You all approved the jury charge, and we're going forward.
Thank you.
All right, are you folks ready to deliver your closing remarks?
Yes, Your Honor.
Bring in the jury, please.
Yeah, you'd think.
All right, ladies and gentlemen of the jury, as I have alluded to, the next stage or part of this case is the final argument of counsel. You will hear from each side, and the attorneys will argue the issues and the evidence presented, giving you their own interpretation of that evidence. As I've said over and over, their remarks would not be evidence themselves, but all of these attorneys have worked very hard in presenting this case before you, and I ask you to please give them due consideration. We will follow the same order that we have established in this case. As you know, the state does have the burden of proof, and will go forward first. Then the defense will present their entire argument, and the state has a brief period to rebut. All right, Ms. Acord, you may proceed.
ladies and gentlemen of the jury. As you know by now, my name is Ashley Akerd. I am an assistant prosecuting attorney here in Raleigh County. I've been presenting this case to you with Tom Truman, who is our current prosecuting attorney. We're here in the matter of State of West Virginia versus Natalie Cochran. And if you all will bear with me, I will have to do some reading as we go. There's a lot of ground to cover here. So the first thing I want to do is thank you for being here. Just very briefly, I know everyone does this, but this has been a long couple of weeks, and we've had a lot of evidence come in this case. So just thank you all for sitting through it with us. Thank you for being here, and thank you for deciding this case. Now, at this point, you all know why we're here and what we've been doing for the last few weeks. My job today is to prove to you beyond a reasonable doubt that this woman, Natalie Cochran, feloniously, willfully, maliciously, deliberately, and with premeditation killed her husband, Michael Cochran. This entire tragedy can be summarized into 3 different blocks of time. September 29th of 2017 through August 26th of 2018, September 1st of 2018 through January 30th of 2019, and January 30th of 2019 through February 6th of 2019, the week that Michael falls ill for the last time. Now, Michael Cochran was 38 years old at the time that he died. He was a father, a husband, and a son. He was a very fit and healthy man. He cared a lot about what he looked like and a lot about what people thought of him. He lived and worked here in Raleigh County. As you've heard, he worked in technology. He also worked with Workforce West Virginia. Ultimately, he was a minority partner in the Business Tactical Solutions Group, in which his wife, Natalie Cochran, was the 51% majority owner. And we'll just briefly talk about TSG. We don't have to get too far into it, but I feel like we need to cover that ground again. TSG is represented through its website to be a leading supplier to the Department of Defense, national security agencies, federal civilian agencies, prime contractors, and nonprofits worldwide. And we've heard a lot about how the business ended up not being super legitimate. In fact, it wasn't at all. But it originally was set up that way. They had filed with the Secretary of State, it had a business license, and it actually was registered with the federal government to bid on government contracts and to be awarded those contracts. It was held out to be a woman-owned small business, which gave it priority in getting contracts. But a business like this required one thing: startup capital. There was 2 ways that the business obtained startup capital, and that's the money that's needed to get it off the ground and get things running in general. The first way was through investors. And what would happen was Natalie would go to her friends, her family, people in the community, ask them to invest in this company. They were promised a return on their investments when contracts were ultimately fulfilled. They'd get more money back than what they put in. And sometimes, when the money would come back, she would ask them to invest again so they could get an even higher return on their original investment. So some of these people were putting money into this company over and over and over again and seeing very little payout, if any. The other way that TSG gained startup capital was through loans. She would apply for small business quick capital loans. And what that means is these were rescue loans. These were for companies that were in trouble. They would have a very high interest rate, and you would have to pay back on them daily. And now, I'm not saying that Michael didn't know about investors and didn't know about loans. He knew people were investing. He knew there were loans. But they weren't what he thought they were. Some of the loans, he was told, were SBA grants. What's so special about a grant is that you don't have to pay the money back. That money is given to you for a specific purpose. Otherwise, he thought they were getting government bonds. Specifically, Natalie held out the loan companies to be factoring companies. And what factoring companies do is they buy all of these accounts receivable that you have, and they'll pay you for a portion of them, and then they'll collect the money later. So that's what she told him was going on. So what happens next is about August 26th of 2018, Michael really discovers the extent of family investors and investments. You heard that he got into Natalie's phone at one point and read her messages, and that's how he found out. He was completely unaware of the lucrative returns and profits that were being promised to people. He was quoted as saying she was giving away our money. On August 27th of 2018, Natalie sent a message to a few family members, which we've put in evidence and you all have seen. Hey guys, after the contracts that are out pay off, I will have to stop subcontracting. I wasn't as transparent with Michael as I should have been. After this, Michael and Natalie made rounds to family members, trying to pay some checks, trying to pay some people back. But ultimately, Michael realizes that the amount of money that they owed people is a lot more than he knew. So now he wants to be more involved and understand how everything works. On August 27th of 2018, Natalie sends Michael this message, this series of messages. 3.45 million should post tonight at midnight. 300,000 should post Wednesday. 1.25 million on Thursday. 724,000 Monday of next week, and 2.56 million next Friday. You've heard that Michael was spending money. This is why. This is why he was so charitable. You heard that he donated a weight room to a middle school. He bought uniforms for youth sports. He bought a house for a youth pastor who had nowhere else to go, and later rented that house out to Chris Davis's recently widowed aunt. He was trying to give to people. And he'd been led to believe that this legitimate business was thriving and all of this money was due to them. She set a prize date, though, when she did this. All their hard work was going to start paying off at midnight. So what did this ultimately do? It created a big problem. It created a bunch of promises that Natalie couldn't fulfill. And those promises totaled, at this time, $247,499,232. So in our next time frame, Natalie starts to claim that the government is conducting an audit of TSG. And she uses this as a reason that they can't pay money to investors, a reason they can't get contracts, they can't get paid on outstanding contracts, and the reason that they're not seeing any returns. So she solicits 2 more investors. One of those was Chris Davis. He told you about that. She obtains 3 more rescue loans. On October 25th, Natalie tells Michael the audit is complete. We're going to have our money October 29th. So what happens right around that time? October 31st, Michael goes to the hospital. He's expecting $248 million on October 29th. The money isn't produced. On October 31st, he's sick. He goes to the hospital, and he gets discharged, but he's not well. He's not better. And the defense would have you believe that Michael was incredibly sick all the time, that he left the hospital, went back to the hospital because he got sick all over again. No. He was sick one time. He just didn't get better. It happens. It happens all the time, all over the world. When Michael went back to the hospital on November 2nd, Natalie reported that he had had a seizure. That was never confirmed. You heard experts testify that the seizure activity in the records was reported by the defendant. Everyone else who testified said they had never seen him have a seizure. At that time, he had his friend Chris Davis take him to the hospital because he wanted to be treated. Nobody wants to feel the way that Michael felt. But other than this, he was healthy. You would think that he was sick, though, because he was stressed out of his mind, because he was waiting for $248 million that had been promised to him that he hasn't seen. But it still isn't coming, and there's a whole lot happening during this time. A phrase that we've been throwing around a lot on our team is that Natalie Cochran involved everyone and included no one. So on December 4th, BB&T is closing the Cochran's accounts. Michael goes to BB&T, and you've heard about that. He is irate. In fact, his friend Chris Davis is called to come down to the bank because Michael is causing such a scene that there is fear the police are going to be called. He's angry because he thinks these accounts closing is why he's not seeing any money. So ask yourselves, if Michael was involved in a felony-level financial crime involving hundreds of thousands, at this point hundreds of millions of dollars, why would he go cause a scene at a bank and potentially get the police called on him? He didn't know what was going on. And this is where Natalie gets lucky for the first time. On December 6th, the government's already partially shut down and is only funding certain departments. Now, I'm sure we all remember the government shutdown because it was a really big deal and a lot of people had a really hard time because of it. On December 22nd, the entire federal government shuts down. So we've gone from an audit to a federal government shutdown, buying her more and more time. And the shutdown becomes the reason that they're not getting paid. Now, Natalie has told Michael and all the investors that the money's frozen because of an audit. Now, the government's shut down. Next, she tells people she has cancer, chronic lymphocytic leukemia, which we talked about that a little. We've never found anything that indicates that that was real either. She now has to deliver. So she tells Michael and she tells the investors, on February 1st, the federal funds will be released because the shutdown has ended. So why does the money come in on February 1st? It's January 30th of 2019, and we have entered the week of Michael's illness and ultimate death. So here is where she gets sloppy. Her motive to kill him becomes very clear because he is very quickly catching on. It becomes very obvious who's been running the company, that Michael has no idea about the Ponzi scheme, and more importantly, we're seeing that Michael's about to discover the truth of everything that's been going on. So she has two choices. She can come clean, or she can go into self-preservation, which requires that she take him out of the equation and make sure he never finds out what was happening. January 31st of 2019. Natalie says, I'm on the phone with Bank of America. Michael says, are we 1,000%? Yes, she's sending them with tracking. Money is supposed to hit tomorrow. February 1st of 2019, the fund release date told to investors and told to Michael, no funds hit any accounts. This was a Friday, so Michael knows at this point Monday is the next day he can do anything. So, on Monday, money isn't in there. More excuses. Michael is getting increasingly concerned. Later that same day, she says that she spoke with the wire department. All of this money is about to come through. 4.8 million in the morning, 23.8 tomorrow sometime. Michael says, shit, can't do anything today. Michael was just like the rest of us, as you can see. Doesn't make any sense. I certainly don't think it makes any sense, ladies and gentlemen. And that's because nothing he was told was true. So let's get into Michael's murder. February 4th of 2019, Natalie sends Michael a text message. I'm at the pharmacy. Need anything? Now, if you'll recall from Dr. Halsey's testimony yesterday, on February 4th of 2019, Natalie was picking up her prescription for Xanax. which Dr. Halsey also testified is a benzodiazepine. Michael is allergic to benzodiazepines, as you've all heard. On February 5th of 2019, Natalie goes to Access Health and sees Dr. Halsey with flu-like symptoms. She says she's vomiting, she reports a fever. She's negative for the flu and strep. She got a steroid shot and labs that day. Now you'll note that this is the doctor who, she said, put her on such a high dose of steroids. That was her words, high dose of steroids. As we'll later see her tell Jennifer Davis. But he didn't give her a prescription for insulin. And you heard his testimony yesterday that he didn't instruct her to get insulin. On this day, she also requested methylprednisolone from Stephanie Hamilton. Now, we all know that is Solumedrol. And if you'll recall, a vial of methylprednisolone was later recovered from the Cochran residence when the search warrant was executed. FBI analysis told us that that bottle had never been used. The same day, Natalie reaches out to Albatross Air, the Kearns family, and schedules a flight for her and Mike to take the following day to Lynchburg, Virginia. We've heard a lot of talk about that flight. You heard from Court Nexon, who is a former Bank of America employee. And he told you that the Cochran's account was never funded. There was never money in their Bank of America account. Mike couldn't understand why. So sure, they were going on this trip to fill out signature cards and things like that. But they were also going to find out why contract funds weren't posting to this account. Why all of these wire transfers we've heard of were not coming through. And if they went on that trip, it would have changed everything. So on February 6th of 2019, the last day that anyone sees Michael Cochran conscious, 6:34 a.m., Natalie Cochran texts Chris Davis. She tells him she can't go to Lynchburg because she has a fever of 103 degrees. Now you'll recall she asked Stephanie Hamilton to bring a thermometer over because she apparently didn't have one. 6:35 a.m., Natalie texts Josh Kearns at Albatross Air, cancels the flight to Lynchburg because she has the flu. Mike tells Natalie to tell Court Nexon and his boss that they won't be there today because she's sick and they'll come tomorrow. But if they still need him to come today, Mike will go and he'll take his friend Chris Davis with him. They'll come back and get her signature card notarized. Mike very much wanted to take this trip. 6:37 a.m., Mike tells Natalie to get Court Nexon to wire them $5,000 to $10,000 from their account. The account that is still sitting empty at Bank of America. Natalie tells Mike she's already canceled the flight and he tells her to reschedule it for the next day. And this, ladies and gentlemen, is the text canceling the flight to Lynchburg, wherein Natalie says that she's been up all night with the flu, which we all know she was never diagnosed with. Later on February 6th, she sends this text message to Michael. I'm in the doctor's office getting swabbed again, getting a Prometh shot, getting you and I both meds. Now Mike is currently out and about in town. He goes and gets some Starbucks at 8:37 in the morning. Natalie arrives at Access Health at 8:10. And she says she's getting them both meds. Now you heard Dr. Halsey testify yesterday. He didn't see Michael that day, and he did not prescribe anything for Michael that day. In fact, the only medications that Natalie was prescribed that day were promethazine tablets. Promethazine, which Michael is critically allergic to. So what did she tell him that she got him? And isn't it interesting that Natalie Cochran runs straight to the doctor at the first sign of trouble? Frequently. But let Michael Cochran lay on the couch for 6 hours, unconscious. And let's ask ourselves how Michael was feeling around this time. Well, you remember Jason Bowen telling you he, quote, felt like he was being poisoned. She later texts Jennifer Davis, "We are both sick. So they put me on such high-dose steroids I have to start taking small insulin shots. Gonna have to order a vial." Again, there's no records that support any of this. There's nothing that indicates that she needed insulin for any reason at all. And if Mike was really keeping insulin in the house for his bodybuilding that everyone keeps talking about, why couldn't she use that? Why would she need to get it somewhere else? And I'll also add, the last text between Michael and Natalie Cochran is at 8:51 a.m. on February 6th. Following that was a 15-second call at 8:52 a.m. And this is the last time we know of that they spoke with each other. Later on, as we all know, Jennifer Davis offers up a vial of insulin because she's a good friend. She's worried about Natalie. She thinks her friend has cancer. She thinks that she's dying. She's doing everything she can to help. So she offers up her own son's vial of insulin. Natalie sends another text to Jennifer Davis. "Mike's sick today too. He didn't get anything prescribed for him. He didn't go to the doctor. All that we've heard is that he laid on the couch for a couple hours." Chris Davis shows up a little while later, and as we all know, drops off a bag, which he testified that he never looked in. His wife, Jennifer, told us exactly what was in the bag. Some Propel, a Diet Coke that Natalie asked for, and a brand new, unopened vial of Humalog insulin. Jennifer says, "You're welcome, but that's nothing. I sure wish I could do more for you." And Natalie's words are, "That was perfect." And I bet it was. Another message she sends Jennifer Davis, "Mike was so mad this AM about not being able to go today. He had to take 2 of my blood pressure pills." Now, the last documented communications from Mike's phone, 11:15 a.m., John Hamilton told you he called and didn't get Mike. He leaves a voicemail message. 1:39 p.m., which you heard testimony today, we believe Michael was unconscious at that time. A text goes from Michael's phone to Matt McCormick. "Should be good, buddy. I'm available all weekend too. Whatever works best." "12:29 on February 6th of 2019, Natalie Cochran takes this photo of her husband Michael laying in their kitchen floor. Now, ladies and gentlemen, I don't know about you, but if my husband had a serious medical event and was lying unconscious in my kitchen floor, I wouldn't be taking pictures of him. I'd be getting help. The first person she sends it to is her sister Penny, who testified that her reaction was, "Well, what does she want me to do about it?" And I think we all know the answer to that question. Next, she reaches out to John Hamilton, who you heard testify a few days ago. She tells him, "Mike is sick like last time. Last time when he asked to be taken to the hospital. Last time when he wasn't left unconscious in his kitchen floor." John heads that way, and Natalie then calls her private contractors, Jason Bowen and Jonathan Miller, to come to the residence and help. You heard Jason testify that they were at Lowe's at the time. The story he was given was that Michael threw up in the sink and then used the kitchen cabinets to lower himself to the floor. Jason and Jonathan arrive, and they move Michael to the couch, and Natalie begins reading them vital signs that they can't see. That includes his blood sugar. Why would you check the blood sugar of someone who doesn't have diabetes or any known problems with regulating his blood sugar? Ladies and gentlemen, I'll posit to you that if he were just sleeping it off like she wanted him to do, he would have felt that finger stick. I've had 100 finger sticks. I know what they feel like. You're not going to sleep through that. At that point, she reports that his blood glucose is 145, and this is at 1:06 p.m. John Hamilton shows up shortly after that, maybe 20 minutes after she contacted him the first time. He told you that Michael was already laying on the couch when he got there. He immediately asks, "How are we going to get Michael to the hospital?" Natalie's response is to let him sleep it off. She now tells him that Michael was sick and had a seizure. John noted that he had never seen Michael have a seizure. John then contacts his wife, Stephanie, who is a physician assistant, as you all heard. He asks her to come over and, quote, get her to take him to the hospital. So Stephanie arrives a little later and takes Michael's temperature. She made it a point not to startle him and even warned him that she was going to be taking his temperature. But he doesn't wake up. Stephanie also tells Natalie that Michael needs to be evaluated. Natalie again declines and says Michael wouldn't want to wake up in a hospital. Stephanie even gave her an out. She said, he can blame me. Also, at some point during the day, Natalie and Mike's kids come home from school, and Natalie's sister, Penny Lowry, arrives. Penny told you that Michael had an accident, and she held a blanket up while Natalie changed him into dry clothing that was retrieved by Natalie and Michael's daughter, Nicole. Thomas Treadway shows up later. When asked if he believed Michael needed to go to the hospital, he told you he's not a medical professional. Natalie's text messages indicate otherwise. They indicate that he believed Michael was getting worse and that he needed to be checked out. So you decide. At 4:34 p.m., Natalie reports that Michael's blood glucose is 115. She tells others that Stephanie Hamilton took that reading, but Stephanie Hamilton took the stand and told you that was not true. Lastly, Chris Davis, Michael's best friend by all accounts, arrives at the residence. He told you how he ran his thumb up the sole of Michael's foot to see if he could startle him awake. He told you that he tried a sternal rub. Nothing. His words to you were, he is going to the hospital, and I'm going to take him. At that point, he and Thomas Treadway load Michael into the back of the Cochran's car, where Natalie rides with him as Chris drives him from 4H Lake Road to Raleigh General Hospital. When Michael arrives at Raleigh General Hospital, his blood glucose was 21. That's a far cry from 145 and 115. Seemingly, it's plummeted out of nowhere. You heard from Dr. Uribe and Dr. Krieger. The only reasonable explanation is exogenous insulin administration. And ladies and gentlemen, the defense has posited to you that if Natalie Cochran injected Michael with insulin, oops, dropped the needle. Here's the good news, I brought it back up. He would have felt it. Now, this is an insulin needle.
Your Honor, I'm going to object to this demonstration. This is bringing outside the evidence before the jury.
This is a demonstrative exhibit, Your Honor.
Overall, it is a demonstrative exhibit used in closing arguments. Members of the jury, you are the judges of the evidence. This is a demonstrative exhibit. I want you to rely upon your recollections and your memories of what the evidence has been in making your decision. There's a certain rough and tumble that we allow and some latitude in terms of closing remarks. I'm going to, as I say, overrule the objection and permit counsel to proceed.
Thank you, Your Honor. Ladies and gentlemen, I want you to see the size of an insulin needle. That needle I just showed you holds 30 units of the kind of insulin that Gavin Davis was prescribed and that was received by Natalie Cochran from Jennifer Davis. Dr. Krieger told you how small a unit of insulin is, and you can see it for yourself. Extremely small. I would also say, we made it pretty clear yesterday that the defense experts did not have the full picture. They had incorrect and incomplete information, so how could they make an informed opinion? And when Michael arrived at Raleigh General, as I said, his blood glucose was 21. He was immediately intubated, and he never woke up. February 7th through 11th of 2019, Michael was transferred to Charleston Area Medical Center, CAMC. His MRI there, as you've heard, showed diffuse hypoglycemic encephalopathy, brain swelling caused by low blood sugar. February 10th of 2019, Michael is transferred to hospice care at his wife's request. He spends 5 hours there before he dies. Now you'll recall during Thomas Treadway's testimony that he advised Natalie needed to remember that she took his vitals that day and that she needed to make a timeline of the events leading up to Michael's death. Why? Here's some of the different stories she told. Michael was sick in the sink and fell. Michael was sick in the sink and lowered himself to the floor. I heard him hit his head, and when I went in there, he had fallen. She also said he was vomiting in the sink, had a seizure, and then hit his head. And that's just a few of the stories we heard. Now, a search warrant of the Cochran residence was executed on June 25th of 2019. And I would note that TSG has continued business up to this point, even getting additional investors after Michael's death, including the Hamiltons. During this time frame, Natalie also pled guilty to the charges that you heard about in federal court, the wire fraud and unlawful monetary transactions. During the execution of that search warrant, a lot of things were found and taken from the Cochran residence. Of note for us was the unopened methylprednisolone vial and the insulin that she kept in her refrigerator. Now, if you remember when Lieutenant Bledsoe testified, he told you that when he reviewed the property receipt from the search warrant with Natalie Cochran, she flipped through it and immediately went to the insulin. And she said, "I keep that for my neighbor's son who has diabetes." Ladies and gentlemen, as I stated previously, the elements of first-degree murder are a felonious, willful, malicious, deliberate, and premeditated killing. Felonious is simple. Murder is a felony, and it's against the laws of the state of West Virginia. Willful or deliberate would mean that someone took an overt action in furtherance of an anticipated. Dr. Krieger and Dr. Uribe testified that there was no alternative reasonable explanation for Michael's blood sugar to be 21 other than outside insulin administration. She also let him lay on the couch for 6 hours. She brought in all this help over and over just to refuse it. Malicious, showing or having a desire to cause harm. Natalie was a diabetic counselor and a pharmacist. She knew that injecting insulin into a non-diabetic would cause harm. She chose over and over, after repeated pleas from friends and loved ones, to leave Michael on the couch, laying in his own urine. She also showed a complete indifference for human life when she continued to work on contracts and make plans for bingo while her husband lay dying in the hospital. Premeditation. She obtained the murder weapon in advance from Jennifer Davis. And poor Jennifer had no idea what she was getting herself into when she did that. She had a clear motive, and you saw that leading up to this date, Michael was about to find out what she was doing to people. Do we know what he was going to do with that information? We never will, because he won't have the chance to tell us. Michael was killed because following the actions of the defendant, he was admitted to multiple hospitals and ultimately passed away at hospice. Well, there's a couple of defense theories that I just want to go ahead and debunk while we're here. The first being, Natalie was a pharmacist and could have gotten undetectable drugs to kill Michael. Those were defense counsel's words. She did, just not as a pharmacist. She hadn't worked in pharmacy for 2 years at that point. Insulin can be bought over the counter. Stephanie Hamilton debunked this one. She testified that Humalog, the kind of insulin that was used to kill Michael, cannot be bought over the counter and has to be obtained via a prescription, which neither Natalie nor Michael had. Michael was a, quote, ticking time bomb. Michael's previous illnesses can only be verified by Natalie. No one else ever saw him have a seizure. Sure, he went to the hospital, but they were never actually able to verify that seizure activity occurred, only that it was reported at home. By her own words, Mike was doing the best he had ever done in his life. You heard testimony that he forgot where he parked his car. Ladies and gentlemen, I don't know about you, but I forget where I park my car all the time. It's very common. He participated in tough man competitions and Jeep pulling competitions. That doesn't sound like a sick man to me. You also heard that Michael was on steroids. Chris Davis testified that Natalie told him that she was in charge of all of his supplements and vitamins. No steroids were recovered from the Cochran residence when the search warrant was executed. The Mexican supplement that we've heard about turned out to be a female fertility drug that came from Florida. You know who had communication with that company? Natalie Cochran. Ladies and gentlemen, in closing, Natalie Cochran had the means, knowledge, and opportunity to commit this crime. She dosed Michael Cochran with insulin that he was not prescribed and that he did not need. You may not have done the math, but I have. Next Thursday will make 6 years to the day since she injected Michael Cochran with insulin in his home. 5 days after that will be 6 years since Michael Cochran left this earth. 6 years since 2 children lost their father. 6 years since this woman, Donna Bolt, and this man, Ed Bolt, lost their son. 6 years since they were able to see him for the last time. Michael and the people that loved him deserve to have the most thorough investigation that we could conduct. And we've done that. We've done everything we could to show you what really happened to Michael. These people have waited long enough for justice. Michael has waited long enough for justice. Ladies and gentlemen, I'm asking you at this time to deliver that justice and to find his wife, Natalie Cochran, guilty of the first-degree murder of Michael Cochran. Thank you.
Mr. Victor.
May it please the court, counsel for the state, ladies and gentlemen of the jury. About 2 weeks ago, when I stood in front of you, I told you a couple of things about this case. And one was that Natalie Cochran was guilty of financial fraud, of financial shenanigans, and that she was indeed guilty without any reservation. But we're not here today to retry that case. And everything that the state is telling you about Natalie Cochran, yes, let's shed some light.
That was me, sorry.
Thank you, Judge. Everything that we've heard about this financial case from Natalie's standpoint is true. She was convicted. She was a participant in the Ponzi scheme. But we're not here to judge her yet again on the financial crimes. We are here to judge her on the murder of her husband. And the state cannot prove first-degree murder against her beyond a reasonable doubt. The state cannot prove three things. The case cannot prove what, the case cannot prove how, and the state cannot prove why. First question, what was Michael Cochran killed by, or what killed him? And you've heard the evidence over the last 2 weeks that we don't know. The experts that the state brought testified to what they themselves admitted, a definite maybe. Maybe it was the insulin shot, and maybe not. The experts that the state brought testified to, we cannot determine the objective factors, the objective anatomical findings, and tangible demonstrative evidence what killed him. They don't know. The state's expert, Dr. Krieger, said, well, the hypoglycemia due to the insulin administration is a strong possibility, but it's just a possibility. Why don't we know what killed Michael Cochran? Well, because they did not perform the autopsy. And by the time all these experts got the evidence, Michael Cochran's body was so decomposed that it is impossible medically to determine what killed him. And you heard the testimony of two defense experts. And you also heard the testimony of my compatriot, Dr. Piotr Kubitschek, who is the medical examiner who performs autopsies on a daily basis and who is, I would submit to you, a little bit like Matlock. He is the medical detective trying to detect what is the crime that led to the death of that particular individual. All these experts said the same thing. The cause of Michael's death is undetermined. We don't know. The state cannot answer or prove beyond a reasonable doubt the how. How did that happen? How did this murder happen? I'm not particularly good with syringes, but, well, we'll come to that. The state wants you to believe that there was an insulin shot injected into Michael that killed him. But then the state also tells you that it could have been more than one insulin shot. Because when Michael arrived at the hospital, his sugar level was 21. And the experts told you that it's impossible to have that type of sugar level without being pretty much continuously shot with insulin. So, how did that happen? Well, let's follow the state's theory. This cold-blooded killer is planning a murder of her husband with the insulin shot. In that regard, she is calling her friend, Miss Davis, asking for insulin on the day of the injection of that insulin. I might just as well have asked for a gun. Might just as well have asked for a murder weapon. Jennifer, I'm trying to kill my husband later today. I need the and I'm trying to kill him with insulin. I need you to bring me some insulin. Is that the action of a planning cold-blooded killer? She would get that insulin ahead of time, not on the day of the murder, and involve two witnesses against her right there and then, who came here to court as predicted and testified that, yeah, that was, and they gave her the insulin. And then, how on earth did she inject that insulin into Michael? Well, let's look at these facts. Did she approach Michael from the front when he was facing her in the kitchen? And if she had the insulin injection in her hand, wouldn't he have the time to react and say, what is going on? Let's assume for a moment. Then she approaches him from the back when he's standing in the kitchen, and she jabs him either in his back or his rear end. Well, she has to have a couple of seconds to inject this insulin in him. Basic human reaction would be to turn around and face the assailant, be it his wife or be it some cold-blooded killer, a stranger. She wouldn't even have time to plunge in the insulin into his body without him turning around. And he's an athlete. He's this huge guy. And here is his 5'1" or 5'2" wife who's injecting him with insulin, and he doesn't react. That's why I said it didn't happen in silence. My first reaction would be, what on earth are you doing, woman? Or whatever he calls her. What are you doing? And then, somehow, he drops there in a fetal position in the kitchen? No, that didn't happen that way. Of course it didn't. So now, you heard the evidence from at least 4 or 5 witnesses that this type of insulin acts in a delayed way. 10 minutes, 15 minutes, up to half an hour. If I'm jabbed, even by my dearest wife, or by somebody else with a substance, and if she is silent, that's one thing, and if she tells me, this is for you, you son of a gun, I hate your guts, whatnot, here it is, I'm killing you, I would have 10 to 15 minutes, maybe to 20 minutes, to 30 minutes, to call 911, to run to the hospital. I told you, it was 7 miles from the hospital. He would have been in the, I know it's February, but he would have been in that hospital sooner than you can say hello, sooner than you can slap a tick. He would have been in that hospital asking for help, an immediate sugar reaction or sugar injection to bring that insulin level to some normalcy. He wouldn't have taken it in silence. He wouldn't have just dropped down on the floor. So how did it happen? Well, the state then gives you an alternative, because now they're changing their theory. That may have happened in bed. Ah, that's a novel idea. Inject him in bed, he would not have reacted? Of course he would have reacted. He would have gotten up and he would have done the same thing. He would have taken himself to the hospital, he would have called 911, he would have probably not been particularly happy with Natalie, but that doesn't mean anything. He could have saved himself. So then the state changes the theory again. That may have happened upstairs, or it may have happened on the couch, or he's injected on the couch. Well then, okay, so he doesn't get up, so who takes him into the kitchen and puts him in this fetal position? That didn't happen, ladies and gentlemen of the jury. And how do we know that? He fell in the kitchen because there was one witness, and he hit his head against the counter because there was one witness, and that was the sister of my client, who told you that she saw a dent, a fresh dent in the counter, in the kitchen counter. That's where he hit his head, and that's how he fell on the ground, on the kitchen floor. But not because some insulin injection, but because of some unknown condition that was caused, or may have been caused, by many, many, many different reasons. Now, then, continuing with the cold-blooded killer's action, she does not do anything but call all kinds of people to the house. Now, wait a minute. You have just decided to kill your husband. He is unconscious, let's assume, and you want him dead. Well, let him die then. Don't do anything. Or maybe put a pillow over his head and kill him. But do not tell me that you want to kill your husband and then you call 2 workers right there to bring Michael onto the couch. The sister and her husband, the state trooper and his wife, who is a medical assistant, and then Mr. Davis. Is that the action of a killer who wants to get away with murder? No. 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 And then, and again, I told you, that's the kicker. Then he dies, and she wants to hide all the evidence. She cremates him. And then all the evidence is gone. All these Dr. Kubitscheks and everybody else can look at all that evidence. No, they can't, because he's cremated. That's how you, I guess, kill somebody the way the state believed it happened. But it didn't happen that way. And then the ultimate question, and the question is why? Throughout this case, the leitmotif, the state's main motif in this case was Michael didn't know anything about this business. Didn't know anything about Natalie's shenanigans, financial, the fraud, the deception, the lies. He didn't know anything about it. Well, I think that from the very first day, ladies and gentlemen of the jury, you've realized that this is not the case. But let's assume for a moment that Michael is indeed blind and doesn't know anything about millions of dollars, hundreds and thousands of dollars. He doesn't realize where all that sudden wealth came from. Doesn't know anything. And then he finally finds out. Let's assume that he finds out. And then the state tells you that he would do what? Well, the state cannot tell you. And the question is, what would he do? What would he do that would be so bad that would require Natalie Cochran to kill him? I mean, scenarios abound. You find out that your spouse is cheating the government, cheating the investors. What do you want to do? Well, you probably want to say, come on, let's get a lawyer. Let's get an accountant. Let's try to work it out. Let's call these investors. Let's try to pay the money back. Let's file for a bankruptcy. Let's maybe even talk to a friendly prosecutor in Raleigh County. Maybe you will have to do a little bit of time. But not run to the federal government and complain. What, was he going to kill her? Is there any evidence that she launched this preemptive strike against him because he was going to kill her? Or that he was going to do something to her? Divorce her? What? What would be her motive to kill him? Why? She may have been afraid that he would be mad, but to kill him? To eliminate him? From what? From doing what? From going to the federal government? From complaining that my image is so tarnished now in the community that I want to divorce you and you will be penniless and all of that? There's no evidence of that, ladies and gentlemen of the jury. What triggered this murder? The state cannot answer that question. But if you had any doubts about Michael being involved in this scheme, and if you believe that he was, then the state's entire case collapses. Because she, Natalie Cochran, would have no reason to kill him. Because he, Michael Cochran, was as involved in this conspiracy as she was. And how do we know it? Well, he was working on these contracts daily, on these federal contracts daily. Even when he was hunting with his little son, he had a contract that he was working on. He was working on the contracts when they were in bed. And I'm not talking about anything sexual here. I'm talking about family. She's watching the TV. He is working on the contracts. Their little son with them, sitting between them, realizing that daddy's working on the federal contracts. He signs the checks from the company. He has access to everything, every bit of information that goes through this company, checks, contracts. He has access to all of that. And besides, is he really living on a different planet from Natalie? Ladies and gentlemen of the jury, if I suspected my wife, we are, well, unless I'm in court, we're home. We're together. We spend time together. We communicate. Where is all this money coming from? All of a sudden, I'm not working. I'm this computer tech guy. You're not working. All of a sudden, we're buying 2 boats. Well, the investors, yeah, but now we have 3 houses. Now, we just got back from Paris. Ladies and gentlemen of the jury, you've heard the evidence of incredible wealth, incredible injection, maybe that's a bad word, injection of wealth that Mr. and Mrs. Cochran had in 2018, 2019, maybe even 2017. And that came from the investors. And the investors dealt with Michael individually, just like his parents. They gave him some $44,000. He knew that there were no contracts. What contracts were they? What contracts were there? He didn't have a clue about some of the business, I'm sure. But he had deep, profound knowledge of how much people invested, who was gonna get paid for what, federal contracts. He had deep, profound knowledge of it. I'm sure there were some aspects of this business that he may not even know about. And I'm sure that Natalie was involved in this. But she is not here on trial for fraud. She's here on trial for murder. Well, let's look at the state's case. And mind you, the state has a very heavy burden, and the burden of proof, beyond a reasonable doubt. Well, the state brought the evidence of the pilot who says, well, the flight was canceled. Okay. The banker turned mind reader. He had an idea why the flight was canceled, but of course he didn't. He is mad at Natalie because he had to do all that research for the company and didn't get paid for it, I'm sure. And for him, time is money. So they didn't fly to Lynchburg. Well, Natalie went to a doctor. She was sick. I think that the state attributes all these nefarious things to her, but isn't it just plain obvious from Dr. Halsey's testimony that she was sick? She was sick on Friday and she was sick on Saturday. And what did he give her? He gave her a steroid shot that increases blood sugar. So she's calling her friend, Miss Davis, to get her some insulin to maybe level off the sugar, blood sugar. What's so unusual about it? No, it's nothing unusual about it because she, Natalie Cochran, had a long-standing relationship with the Davises, who had a misfortune, a tragic misfortune, of having a child who was diabetic. And Mrs. Davis came here and told you, no, Natalie never had any insulin. Oh, really? But then when we confronted her with the pharmacy records, she said, oh yeah, Natalie could pick up the insulin. But she was bringing it home. Well, what if you weren't home? Yeah, she doesn't explain it. Natalie could keep it at home. That was nothing unusual about Natalie having insulin. And you know what? The state wants you to believe that this insulin, that bottle of insulin that was found, was the weapon, the murder weapon. That somehow it was punctured and she kept that bottle as some kind of sick souvenir of the murder? Is that what the state telling you? I submit to you, ladies and gentlemen of the jury, if you look all you need to look at is this humologue that we introduced in the exhibit, as an exhibit. I'll submit to you that a blind fool would tell you that this bottle is full. This bottle is full. There is nothing in this bottle that has been taken. There's no bubble, no nothing. The bottle is full. I suspect I know what happened, why there's a puncture. All these FBI gentlemen got that bottle and maybe had taken a little sample of what to determine what it is. That may be the puncture. But otherwise, the bottle is full. We're not going to sit here and speculate. They find a bottle, a vial of insulin that is full 4 months after the demise of Michael Cochran. And then, that's part of their evidence. Remember Mr. Bledsoe telling you at the end when we finally pressed him, is there any evidence? Is there any evidence that the bottle that you have was the murder weapon? And the answer was no. And ladies and gentlemen of the jury, Lifelong condemnation of this woman versus complete exoneration is at stake. The stigma of conviction for murder versus letting her go free is teetering in the balance, and the state has the audacity to come here with an item that is not the evidence, and they're trying to tell you to convict this woman of murder based on something that is not the evidence. Is that the case that the state has the audacity to bring before you? Well, let's look further. Chris Davis and at least one other witness, Mr. Treadway, and Penny Lowry, knew that Michael Cochran was taking all those steroids. Whatever, steroids maybe. Maybe they were steroids. Maybe they were not steroids. Maybe they were anabolics. We don't know. Michael was taking substances by the fistfuls. And they can say that, oh, we have isolated one little vial and that was some hormonal thing from Mexico. No, ladies and gentlemen of the jury. He had a cabinet full of medications. He had a cabinet full of that away from the family, away from the cabinet or a place where the family stored the medication. He was getting this stuff online. He had the United States Postal Service box where he would get all that stuff. And I submit to you that this was not some one deal Mexico thing. And there's nothing wrong about Mexico. This was, however, the problem. He was getting substances that were not approved by the American government, by the, the Food and Drug Administration. He was getting substances that were going to increase his physique, his appearance. But my God, they could have done some serious damage and probably did some serious damage. One of them was not even for human consumption, as the children told you. There was just a sample of what Michael Cochran was taking. And what he was not taking was the medication that was prescribed to him by the physicians. And yes, he had all kinds of conditions for which he had the medications. He had Keppra, he had all kinds of serious medications which he didn't take because he believed that all the doctors were quacks. He believed that they were not the people to be trusted. Chris Davis and Mr. Treadway and Penny Lowry tell him, you have to stop this stuff. You really cannot do this. And what does he tell Penny Lowry? She testifies. He said, "Oh, retarded Penny. What do you know? I'm gonna do whatever I want to." The state makes a big deal out of, Michael not being taken to the hospital. But you have witness after witness who told you that Michael not only believed that the doctors were quacks, but he hated going to the hospital. He vowed to kill somebody if he's ever awakened in a hospital. And why? Because he considered this a waste of time. Now, he had all kinds of problems that he went to the hospital with, and within the last 3 months of his life, he went to the hospital 3 times. October 31st, and then he stayed there for a day. I told him he had all kinds of problems. Then he went back to the hospital with pretty much the same conditions that he had now, and stayed there for 5 days, and then he came out. You've heard throughout this trial that Michael had convulsions, seizure-like activity. He probably had epilepsy. The doctors told you that. He had a brain mass that was later modified into the brain swelling, encephalopathy. Ladies and gentlemen of the jury, those are serious conditions. They are not to be laughed at. Those are very serious conditions. He retained urine. He had an enlarged heart. He had an acute respiratory failure. He couldn't even breathe because he had a chronic sinusitis. Nobody is here to desecrate or dishonor his life. He died much too prematurely. He died at the age of 38 years. Not for a moment should you think that the defense is taking his death lightly. No. It's a horrible tragedy. Horrible tragedy. But a tragedy, not a murder. It's a tragedy, ladies and gentlemen of the jury. But with all these conditions, Michael was still doing what Michael was doing. Taking supplements, anabolics, substances that God only knows where they came from. And who approved them? And he was a ticking bomb. And how do we know that? Well, after his second stay in a hospital, at least 3 witnesses told us that Michael's health has deteriorated to the point where Michael was not the same guy. When he was Michael at his best, he was generous, gregarious, going to parties, participating in tough man competitions, lived life to the fullest. He was focused. After his second stay in a hospital, Michael could not find his car in a parking lot. Forget that. That happens to me quite frequently. But that's not what, that was just one symptom. He could not fix a light fixture with Mr. Davis. He felt confused. The children testified he had constant headaches. He was irritable. He didn't know where he was. Mr. Treadway came here and testified, Michael hated going to Panera Bread with a passion. He hated the restaurant completely. And I know that this is not a case about Panera Bread. But if I hate a restaurant, I'm not going to set foot there. And yet Michael went there and could not even recognize the fact that Mr. Treadway was wearing the same hat that he's been wearing for years. He was confused. There was something going on in his head that made him go where he would never go, and that made him forget who his friend was, really. Now, the state brought before you those 2 FBI agents who, again, could not contribute anything scientific except for that bottle. And the state closed the case with 2 law enforcement officers who are here today. Have you ever seen a more shoddy investigation that took place in this case? They never talked to the children. And I know that the state will say, oh, this was not that important. It was important. The children's testimony was riveting in this case, and I'll come back to that in a second. They did not even check what kind of medication this man was using. And for that matter, they have no clue about Natalie Cochran's medication. And, you know, they try to convict her in part because she lied about her cancer. Oh, that's a low blow. First of all, we have absolutely no evidence that she did not have cancer. We have the evidence that she was going to seek help from the Cleveland Clinic, from Duke, from the doctors, wherever she could. And knowing our medical system in this country, it's not that you're going to walk into the Cleveland Clinic and you get treatment the same day. You have to have insurance. You have to have all kinds of, you have to go through all kinds of hoops to be seen by a specialist. And maybe when she told somebody, yeah, I have cancer, leave me alone, because she maybe didn't want to discuss her health with somebody, maybe in reality she was checking out whether she had cancer and went to all kinds of doctors and clinics to obtain that health. And the state believes, oh, she lied because she told you that she had cancer? The officers ignored the federal investigation completely. And in the federal investigation, in the indictment, in the forfeiture proceedings, in the federal case, it's the Cochrans who were responsible for the Ponzi scheme. But the indictment didn't come until September of 2019, and Michael was dead. I submit to you that the federal government was investigating them both. They can come here and say, well, I saw some cases where the couples were not investigated together. That's baloney. The federal government investigated them both and would have indicted Michael as quickly as they indicted Natalie for the same offenses, because Michael was involved in this Ponzi scheme up to his eyeballs. Now, let's see what evidence the defendant presented. Remember Nurse Hawley, if I pronounce it correctly, Hawley, yes, who said that she was at hospice. And what did she observe? Natalie Cochran was with her husband for the last 5 days and held his hand when he passed away. There's evidence that Natalie Cochran got into a car with Mr. Davis. Well, the state said, oh no, she didn't drive him to the hospital. Well, she didn't drive him, but she was a passenger in that vehicle driven by Mr. Davis. She didn't drive him because she was too distraught over his condition, but she still got into the car and held his hand. Is that the cold-blooded killer? She also testified that Natalie Cochran was a go-to woman, and I think that she may have used that phrase, or maybe I have used that phrase, when it came to the emergency situations involving Mr. and Mrs. Davis's child. So Natalie Cochran would have to have insulin. You don't treat insulin with a water pill, for God's sake. You have to have insulin to treat it. And if she was a go-to woman, she must have had insulin to treat the Davis's child. So there should be no surprise again that she had insulin in her possession. Mr. Treadway didn't want to talk to the police because he believed they were dishonest crooks. And he somehow, by the way, he got scammed financially, so he had absolutely no reason to be friendly to Natalie Cochran and testify on her behalf. Similarly to all these other witnesses, even her sister got scammed to the tune of about 50 grand, and yet she came and testified for her sister. What did Treadway tell you? Well, Michael was confused. Michael wasn't the same guy that he had been before. And then Penny Lowry, the retarded Penny, as Michael called her. She told you, not only about that fresh dent in the kitchen counter, but Michael wanted to pay her back what she owed on the contract. Michael wanted to pay her back. Michael was dealing and wheeling with the money from the investors. He knew about it. She told you, again, the same story, that Michael refused to go to the hospital because he was going to kill somebody if he went back to the hospital and woke up there. And we have all these discussions between 5 or 6 people after Michael collapsed in the kitchen. And then I told you that the children testified in a riveting way. And you're going to tell us, well, the state probably will tell you they're coached, or they were somehow not truthful. Two tragic figures. Two children who were young enough to be taken care of by father and mother, and old enough to know what was going on around their house. Nikki testified here unequivocally that her father had headaches, he was confused, had a brain fog, was agitated. In a true, genuine, heartfelt way, she told you that he may not have been as loving towards her as he was towards their son. Michael had a heart-to-heart with her shortly before he died, and her impression was that her father felt it coming. And what was it? It was death, ladies and gentlemen of the jury. Michael felt it coming, and he had this heart-to-heart conversation with her, which she considered heart-rending, and which we would consider his farewell to life, because he knew that there was something irreversibly wrong with him. The MAC, their son, testified too. Dad worked on the contracts all the time, even when hunting, even in bed. And he testified about their lifestyle. He testified about the supplements, the injections, the dropper, the stuff from Mexico, as he called it. Stuff that wasn't for human consumption. He remembered it all. He testified about his father's anger, his father's combativeness, his father's confusion. Now, I want to talk to you very briefly about, before I do that, there was also a brief mention of nootropics, a medicine that came from some shady, well, maybe not shady, I shouldn't say that, places that usually would not be available in your local friendly pharmacy. There was the smart drugs that Michael was receiving at his USPS, United States Postal Service, box. These were the cognitive enhancers, memory enhancers, stimulants. Michael was perhaps a man's man, and he would not admit to any weakness. He was seeking desperately to look great, to be this, I don't know, alpha male, whatever you call it, to be this great, maybe bodybuilder, maybe an athlete. And yet, in all of this, he didn't follow the advice of those who should have given him the advice and who he should have listened to, and instead did his on his own. Now, I want to return for a second to the experts who testified in this case. let's start with Dr. Kubitschek. All of these experts, by the way, had a number of autopsies that performed. But who was in the best position to tell you about the autopsies? Who was in the best position? Well, of course it was Dr. Kubitschek. He performed the autopsy the earliest. And with all the help of the state resources, and relatively early in the game, when the body was not perhaps yet decomposed to the point that nobody could recognize the organs anymore, he told you that the cause and manner of death was undetermined. Then there was Dr. Howley, who was not necessarily an expert, but he told you a couple of nice things. One is about, of course, about Natalie being sick, but he also said something about tablets, the pills, and the state jumped on it. And now the state submitted another theory that maybe Michael was killed by Natalie with pills. For that matter, the state is bringing another theory now that maybe she killed him with the benzos. You heard about the benzos. Now the state says maybe there were 2 shots of insulin or maybe more. Now the state tells you she killed him in the kitchen. Now she killed him in the bedroom. Now she killed him with the prednisone, maybe. And then maybe any other substance. And the state will stand up at the end and tell you that whatever I tell you is a bunch of nonsense. But, ladies and gentlemen, you've listened to the evidence. If the state stuck to its theory that there was 1 insulin shot, I could buy it. But now the state quietly is telling you, well, we're not telling you that the evidence suggests that the defendant killed her husband with insulin. There may have been pills, there may have been benzos. They're intimating this because they don't have any direct evidence, to which they immediately admitted, but they don't have any circumstantial evidence that fits either. Now, you had Dr. Dragovich, who told you maybe one very important thing, and that is that the decomposition of the body caused the inability of any doctor, for that matter, to assess objective factors, objective anatomical factors, and the findings of any type of specific, concrete reasons for Michael's death. That is impossible. Dr. Uribe believed that there was an insulin shot, but this was just an assumption. It was kind of a bridge to the unknown, and I think that was his phrase. It was just an opinion. Dr. Krieger said, well, we've excluded maybe all the other options, but it's a definite maybe, as we call it. It's a definite maybe. Maybe there was an insulin shot, but we don't really have all that information upon which we can construe our theory. And then Dr. Banerjee came here, and she said, we don't know. She's our expert. Maybe you expected her to say, oh yeah, that was an insulin shot that was responsible. That was some other reason. She didn't say that. She testified like 4 other experts that we really don't know. But there are other possibilities. There was something wrong with Michael's pancreas. Remember that? He may have had pancreatic tumor. He obviously had an enlarged heart. Arrhythmia. Maybe there was something wrong. Maybe that was the reason. The tests were not done on NAC-peptide insulin, no meaningful diagnosis from the sliders that were obtained, or that weren't obtained, could have OD'd on benzos. We don't know. Benzo overdose, maybe poisoning. Hypoglycemia equals death. Well, all of that, and then of course there are other reasons. The medication, alcohol, unexplained medications, liver disease, sepsis, surgeries, immune system, all of this could be taken into account in Michael's death, but the state stubbornly believes that Michael's death was caused by that one insulin shot, which they, by the way, changed and modified to maybe 2 or 3 on all these versions. It's impossible. Impossible, ladies and gentlemen of the jury. Now, the state also brings a theory of maybe there is this voluntary manslaughter, that just because she didn't take him to the hospital. Well, I submit to you that not taking Michael to the hospital was not done over the period of days. It was a matter of hours. It was a matter of discussing Michael's preferences and will, whether he was going to go to the hospital, whether he wanted to go to the hospital, and what was necessary. We had several people in that house who could have decided. Finally, it was decided that Michael was going to the hospital because he was not waking up. Yes, it took some time, but there was always the hope that he would wake up in his own home, surrounded by family and friends, and everything would be fine. After several hours, yes, it became necessary to take him to the hospital. But that's all. Now, ladies and gentlemen of the jury, I told you at the very beginning of this case that this is a complex case. This is a case that involves medical, banking, scientific, maybe pharmaceutical, maybe business evidence and information. There are aspects of federal litigation here. And you've heard it all. But distilled to its essence, this case really involves the state's attempt to equate the federal prosecution and conviction for dishonesty and fraud with murder. The state says she is a fraud, therefore she is a murderer. She is a cold-blooded murderer because she is a cheat. That's what the state is telling you. But the state cannot prove, certainly not beyond any reasonable doubt, the what caused Michael's death, the how did that happen, and why it happened. And so at the end of this case, I will tell you that the state's attempt to equate the fraud with murder is like trying to squeeze a square peg into a round hole. And if that one peg didn't fit, then the state switched the theory, and let's see if another peg that is still square will fit into that hole. Oh no, it won't. Well, then we'll switch to another theory. Maybe benzos, maybe two shots of insulin, and it still doesn't fit. Ladies and gentlemen of the jury, the state will have the last word. In the criminal process, I will sit down and I will not address you again. my esteemed colleagues and friends will get up and tell you that whatever I told you is nonsense. They will give you the spin on the facts and tell you that's the way it is. But I heard a statement once that, and of course when you go to the jury room, since they spoke last, you will have their words in your mind, in your memory more than mine, than my words. But I heard a statement once that it's not the one who speaks last, or trust not the one who speaks last, but who speaks the truth. We have no reason to come here and hide anything from you, ladies and gentlemen of the jury. Ms. Cochran should not be perhaps invited home for you to have dinner with her on Sunday. I told you that. She is committed crimes of fraud, crimes of mail fraud, crimes of dishonesty, but that doesn't make her a murderer. And if you cannot answer these three questions, what, how, and first of all and foremost, why, then the state fails to prove its case beyond a reasonable doubt. And that's why we're asking you to find her not guilty.
A reply, Ms. Akron.
No, it's back to me. You are so close to listening to all the stuff. Be silent on this side, and then you will take over. On behalf of the prosecutors, excuse me, in fact, of the prosecuting attorney's office, the investigators, we thank you for your time, your effort, your attention, your sacrifice. Without you, this system cannot work. Can I touch your equipment? I should have asked. Do you need to hit this? Sure. I can make duck shadows on the wall while we get this going. Pointless maker. Okay. Yeah, I'll talk about something else here in a minute. I'd like to talk with you about two numbers. And the first one is this one. 0. The defense is right. We're going to tell you that what you just heard is a lot of nonsense. And the reason why it's nonsense is the defense has no credible evidence to back up any of their theories as to why the state is wrong. Let's start out with Michael Cochran himself. They have a very schizophrenic approach to Michael Cochran. One theory of the defense is he was this macho, bodybuilding, fit guy, athlete, Jeep pulling, super stud guy. That's one theory. Now, they have some evidence that he was very concerned about his fitness, very concerned about his appearance. We would agree with that. But did that lead to his death? Zero evidence to support that. On the other side, oh my gosh, the guy was a ticking time bomb. The defense words, a ticking time bomb. He was so sickly. He was essentially a guy with 1 foot in the grave and 1 foot on a banana peel. They don't really have any evidence of that either. He was just a normal 38-year-old healthy male. And a good guy by all accounts. So the hospitalizations that they've relied upon to tell you how sickly this man was, where did most of the information come from that? Medical records. Who provided histories for that? The defendant. The defendant told the doctors all of these things about Michael Cochran. It didn't come from other reliable sources. It came from a very unreliable source, her. So his suspected brain mass, his suspected convulsions, his suspected all of these problems, there was no diagnosis of any of those things. They were suspected. And they were suspected because she told them to suspect that stuff. But there was never a diagnosis. Even their own experts confirmed that. There are other witnesses. The fact that the Davises talked to a nurse to have Natalie Cochran, their emergency contact, that's not the same thing as authorizing treatment by Natalie Cochran of any child. There's zero evidence of that. There is evidence on the other side. The Davises told you they never gave the defendant insulin for the benefit of their child. Never. Both Davises told you that. As recently as yesterday, the defense was still putting that theory out there for you to consider. There's no evidence to support that. Zero. Mr. Treadway's testimony was Mr. Treadway's testimony. This is a guy that didn't want to help the police. Even though his best friend was dead, he wouldn't talk to him. And he had some newspaper article he said gave him justification for that. That's on him. Treadway's got to live with that. But he didn't bring anything of substance to this case, did he? No. The two children that testified, they are tragic figures. They have had a terrible 6 years. They lost their dad. For the time being, they've lost their mom. But they were little kids. And their testimony had a certain ring to it. They both picked up on the same word, agitated. That's an unusual word. Rolling back time 6 years, think that the oldest was 20. She was 14 at the time. And that's how she's going to describe her dad the last few weeks of his life, the word agitated. Her brother, the same word, and he was younger than her. There's something odd about that. The state believes that they sincerely believe their recollection. But does it make sense? Would kids that age really be that involved in their parents' business? Would they? Well, it's possible, but that's not very likely. The defense experts, nice people, very sincere, but they're in a little silo. If those forensic pathologists can't cut on a dead body and come up with a smoking gun reason, then their opinion was they won't give you a cause of death or a manner of death. Even though Dr. Banerjee said, oh no, we don't do this in darkness. We look at all the facts. We look at all the circumstances. And the autopsy is just a part of the process of determining these things. But was it? Did she have any facts that were right at all? She had a few, but not many. And in her own report, she said, if other information is brought to my attention, I reserve the right to change my opinion. Well, she had a bunch of other information, but she still wouldn't change her opinion. Why not? That's just her mindset. Did she have any experience in insulin cases? This was her first case, her first one. Dr. Drakovich, apparently he didn't have any insulin experience either. Now, the defense told you that the state has just gone all over the lot with its theories. Is that your recollection of the evidence? Did you hear any state witnesses say there was one injection of insulin? No. Did you say multiple? Because we don't know. But there are some things that we do know. And let's talk a little bit about how that balances out what the defense just told you. There's a lot of circumstances that need your consideration. First of all, this is a trained pharmacist, a pharmacist who knows about all sorts of medication, the impact of the medication, the dosage of medication. Beyond that, this defendant held herself out as a diabetes specialist. A diabetes specialist. That's another circumstantial piece of evidence to keep in your mind. On February 6th of 2019, on the basis of a supposed counterbalance to her cancer treatment, she needs to borrow a bottle of insulin. Another circumstance that needs to be held in the back of your mind. Because on that day, they were supposed to fly to the Bank of America. And yes, there is a merger with the federal case and this case, and that's where the merger takes place. You heard Trooper Heinzman discuss all of the things that the defendant had told her investors about the money that was supposed to be coming in, the money that was going to be coming in, the money that was almost going to come in, and it never did. Who else did she tell that to? Michael Cochran. So when the defense says, oh, he was up to his eyeballs in this, was he? Does the evidence support that? They have zero evidence to support that theory. Zero evidence. He did live a lavish lifestyle. But if he thought that the money was there for good cause and that the business was just supporting that lifestyle, was there anything wrong with that? Of course not. But this was a person who ran a Ponzi scheme. And the one thing you can count on for people that run Ponzi schemes is they will do whatever they can to keep it going. Is that what she did? That's exactly what she did. She was still shucking and jiving after Michael Cochran died. Right up until they executed the search warrant, she was doing ordinary business. Selling the non-existent contracts, trying to get people to invest. So there is zero evidence that Michael Cochran was up to his eyeballs in this, but this defendant was up to her eyeballs and over her head in this fraud scheme, by their own admission. Second number. $21. That's a big number. And that's the number we're going to rely on to convince you beyond a reasonable doubt that this defendant killed Michael Cochran. That number was the number of his blood glucose level at Raleigh General Hospital at 8:30, the day of his collapse. Now, unlike the defense witnesses, the state witnesses were unified and very clear as to what caused that 21 number. Dr. Krieger had 13 likely causes of low blood sugar, hypoglycemia. She eliminated all but insulin. And she's got a good reason for all of them. You heard her testimony. All of those were potentially valid causes of the condition that led to the brain swelling, that led to the death of Michael Cochran. All of them. But she eliminated by logic and by her scientific skills and experience in insulin cases that it had to come from insulin. Dr. Uribe, another experienced insulin investigator, Both of those two were involved in the Clarksburg VA murder cases where a nurse was killing veterans with insulin. Those two were the government's star witnesses. They know what they're talking about when it comes to insulin. And it comes to insulin killing people. That's what they do. So that 21 was never overcome by a single shred of credible evidence by the defense. Not once. No one's told you from the state that there were single injections, multiple injections. We don't know the answer to that. We do know that Michael Cochran's death was caused by insulin and reducing his blood sugar to a fatal level, and the resulting changes in his brain killed that man. Circumstantial evidence is the basis of this case, and let's get this a nice, straightforward example of what that is. It's January in Raleigh County. You look outside your window and you see frost on your neighbor's truck, frost on the ground. Stars are out, moon may be out. You go to bed. You wake up the next morning and there's 8 inches of snow on top of the truck and on top of your grass. Did you see it snow? No. Did it snow? You absolutely know it did. That's circumstantial evidence. Ladies and gentlemen, the state of West Virginia has dumped a blizzard of circumstantial evidence on this defendant. Until today, 2 weeks in an American courtroom, and until today, you never heard the word justice. Well, do justice for Michael Cochran. Find this defendant guilty of first-degree murder, because that's exactly what she did. Thank you.
Members of the jury, you have now reached the final stage of the trial. This is the point where I would ordinarily release the alternate jurors and send the regular jurors to the jury room to deliberate upon your verdict. I see that the time is almost 15 till 5. Ordinarily, I would close out the day at this time, as you know, and send you home for a nice dinner and watching TV and then going to bed. However, you folks are in the catbird seats. You are the judges of the facts, and you can tell me at this juncture what you want to do. And if you would like to retire now to deliberate upon the verdict, that would be fine. We will stay here and we will wait until you reach a verdict. However, if you would like to start afresh tomorrow so that you've gotten a good night's sleep and you can think a little more clearly, you can come back at 9 o'clock at the regular time and commence your deliberations then. We have talked among the attorneys about engaging in a powwow among themselves, and I would urge you to engage in a powwow among yourselves and see if you can reach some unanimity on what to do. Again, you can stay this evening and deliberate, or you can come back tomorrow. Perhaps you can confer for a moment or so and decide what you all would like to do. I'm hearing tomorrow. All right. That's the decision I would make, but again, I'm not you guys. I'm not going to release the 2 alternate jurors. I'll ask you folks to come back with us because I've been at this game a long time, and I know that anything can happen with jurors, in terms of sickness and accidents and that sort of thing. We've done really well, and you folks have been great. You've been here promptly. You have watched and considered everything. I've been sneaking looks at you, and I noticed that you have done very well in terms of paying attention to the evidence and the proceedings. So I will ask all of you to come back tomorrow. Even though we have reached the deliberation phase, you still can't talk about the case because you haven't started your deliberations. And I'll tell you in the morning that you all need to be together. You all need to discuss the case together and not break out into factions or have folks wander off. You need to talk about this together and share your concerns and share the issues that you have arrived at. So that will be to start tomorrow. I'll tell you about selecting a jury foreperson in the morning, and we will get down to business. So if you could all be back in your jury room at a little bit before 9. Do not discuss the case among yourselves. You're not at the deliberation phase yet. Do not talk about it to anyone else. Don't watch TV about it. Don't do any research online or see anything online. And please don't read anything in the newspaper about this case. Have a good evening, and I'll see you folks at 9 o'clock in the morning. You may follow the bailiff. All right, are there any matters we need to discuss at this time out of the presence of the jury?
Nothing from the defense, Your Honor. Thank you.
All right, thank you very much. I appreciate your cooperation in this trial. We will return at 9 a.m. in the morning and see what develops. Court is adjourned.